Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. The first case on for oral argument this morning is People v. Birch, case 21, People v. Birch. Morning.
Good morning. Abigail Whipple for Hezekiah Birch. Ms. Alini Young from my office will be arguing this case under a practice order. She'll be back in Rochester tomorrow actually to be admitted. So I'll hand it off to her at this
Welcome.
point.
Good morning, Your Honors. May it please the court, Lena Young on behalf of Appellant Hezekiah Birch. In this matter, Hezekiah was not able to establish his knowing and voluntary assent to the appeal waiver in this case because he was merely asked a series of repetitive yes or no questions. He was not able to explain the terms of the appeal waiver in his own words, which would have confirmed his full understanding of the waiver prior to signing it. This is especially important in this case because Hezekiah has been diagnosed with PTSD, ADHD, ODD, and bipolar disorder, and he has been on and off of a litany of medications to control his mental diagnoses for years. And his therapist wrote that he has failed to meet developmental milestones due to these mental health diagnoses. Given his young age and vulnerable psychological state, Hezekiah should have been given the opportunity to demonstrate his full knowing and voluntary assent to the appeal waiver prior to signing it. Turning to the youthful offender point, no doubt this is a very serious crime that should not be taken lightly, but Hezekiah should be granted leniency and adjudicated as a youthful offender because of his strong rehabilitative potential. Upon arrest, Hezekiah cooperated with authorities and admitted to all wrongdoing. He apologized to the complainant and their family and admitted that he knows that what he did was wrong. It should have never happened and it won't happen again.
Didn't he already have a OYO adjudication?
To my knowledge, no, he didn't. Hezekiah,
He had PIN's adjudication.
I'm sorry.
He had a person in need of supervision adjudication prior to this.
Yes, prior to this in a separate matter, he did, Your Honor.
Did he
Hezekiah,
also have 2 prior convictions?
I'm not 100% aware of his prior convictions, but I know that this is his first and only felony.
Okay.
But he apologized.
Yes,
He
Your Honor.
readily admitted his guilt.
Absolutely, yes.
And you're suggesting that he shouldn't have the stigma of a felony conviction for the rest of his life based on this mistake he made as you.
Yes, Your Honor.
Anything further you wish to add?
No, Your Honor.
Thank you.
Thank you.
Good morning, and may it please the court, Will Zickel for the people. The first or threshold issue that I would submit to the court is that there was a valid waiver of appeal in this case, which forecloses the defendant's ability to challenge his sentence, including the denial of a YO adjudication before this court. And there is nothing in this record to question the validity of that waiver. The responses to the questions from the court during the waiver colloquy may have been monosyllabic. That is an issue that has been addressed by this court on numerous occasions. That by itself does not invalidate the waiver. In this case, you also have a written waiver which supports the knowing, voluntary, and intelligent nature of the appeal waiver. The defendant was represented by counsel at the time and indicated that he had had the opportunity to speak with counsel about the waiver itself. So I submit to this court that it should not even reach the merits of the defendant's claims about the denial of the YO status or his sentence overall.
we get to the merits. What's your understanding of the defendant's prior criminal history? Like, looks like he was on probation for 2 misdemeanors at the time. He had a prior YO on a misdemeanor, I believe.
I believe he did have a prior YO, that it was on a misdemeanor that had been reduced from a felony.
He had, it looked like he just had a really troubled upbringing through no fault of his own, probably, but while the pre-sentence investigation discussing his contacts as a juvenile are quite likely.
Yes, there is a lengthy juvenile history here, as well as I would submit to the court a lengthy criminal history based upon his young age. And, you know, sentencing is a balancing act, as this court knows, and it has to, a sentencing court has to take into account those factors that Justice Lindley brings up, the fact that the defendant had some deficits in his childhood. However, I submit to the court that those factors are strongly outweighed by the other factors that a court must consider, including retribution and isolation of this defendant.
Do I read the Superior Court information correct? This was forcible rape that he pled guilty to. It wasn't statutory rape.
No, it was an attempt thereof, but yes,
Yeah, attempted forcible rape as a 14-year-old.
that's correct.
Anything further?
No, thank you.
Thank you. Case 23, People versus Manager of Appellate.
Morning.
Counsel, the opponent is virtual.
Yes.
And he is now with us, and you may proceed.
Thank you. Morning. May it please the court, Sean Chase, serial law officers of Syracuse, on behalf of the appellant, Mr. Spencer Manganiello. Briefly, just want to touch on, while there were generally submitted facts, just one portion of the people's response that I just wanted to comment on, in that the people have attempted to phrase Mr. Maniello's actions of unlocking his phone as a voluntary act. I believe that it's recognized that the police told him they had a warrant that would require him to do so, and acting under the color of that warrant and him responding to that, I would respectfully submit it could never be considered as a voluntary act of unlocking his telephone.
But unlike in Payne is the leading case here, I'm sure you're familiar with it. In Payne, the police forcibly took the suspect's finger and put it up against his cell phone to unlock it. And that fact was dispositive to the Circuit Court of Appeals in Payne.
Yes.
And the defendant lost his argument, Fifth Amendment argument in Payne. That was one of the factors, is that there was no cognitive thinking going on by the defendant. They just took his finger, boom, opened it. They left open at the end of Payne, in their opinion. He said it might well be a different result if the defendant voluntarily or on his own put his finger up to the phone. They're suggesting that there's some thinking, some thought process going on there that would make it, testimonial that he's which finger to choose and so forth.
Right.
Here, your facts fit the exception of Payne, do they not? He was not physically forced to do it. There was some voluntary action there or some thought process involved.
I think it is a little bit more of a testimonial act in showing which combination that is, whether it is your thumb, forefinger, or what have you. Yes, I would agree with that.
Did he have a choice?
That's an interesting question. It's practically speaking, everyone has a choice. You are there and the police tell you that they have the opportunity to do so.
No, the warrant specifically gives the police the right to do so.
It does.
So do you have a choice?
I would argue you do. I mean,
How would you have a choice if the warrant compels you to comply?
Well, I think that is kind of the slippery slope where this warrant could go, particularly when you factor in there's no counsel involved, because your choices are frankly, yes, you do the right, you give them your thumb, forefinger, whatever it is, or they grab your hand and put on there one finger after another. So I think that's probably a question for the court to decide whether or not that is, and to what extent the choice is there.
That doesn't sound like a choice.
I would disagree. I guess I would agree that there is,
You're either going to put it there voluntarily, or I'm going to grab your thumb and put it on myself.
correct.
But that's precisely what the warrant authorized.
It did.
So you're compelled to do so.
Yes.
But your argument is you don't accept the validity of the ruling in Payne. You believe choice or no choice, it's testimonial. When you use somebody's biomedical data on their finger to open a phone, that is testimonial, and that it's suggesting that the defendant in effect is saying, I have access to that phone. That's my phone. And that's your argument, right? So whether the police compelled him to do it or whether he did it voluntarily is besides the point, if I understand your general point.
That is our general theory, that this is direct evidence of his, frankly, ownership more than dominion or control or possession. He is one of a number of authorized users. Now, recognize that's not necessarily before the court, number of people that can do that. I think it's generally recognized and known that's a short number, whether it's 1, 2, what have you, who actually has the total dominion or control or possession of that telephone.
It's clearly incriminating in the sense that it leads this defendant to that phone, to that device.
Yes.
No one disputes that. But the question is it testimonial in the sense, how does it unlock the defendant's mind? Let's assume hypothetically he was handcuffed, his hands were behind his back, and the officers went finger by finger.
Mhm.
He got to the same result, unlocked the phone. He didn't use his mind to unlock the phone. He didn't provide any additional evidence other than his biometric data. Would you, under those circumstances, would that be a Fifth Amendment violation?
My thought is, it's hard for me to distinguish between an officer telling you orally, tell me your passcode, if it's 1, 2, 3, 4, what the numbers is, or
Well, let's be
grabbing
clear,
your phone.
that's not what happened here. This was a
True.
warrant that authorized the officers to move a finger to the phone in order to unlock it. That's what we're talking about in this
Right.
particular case. And your contention is that somehow putting your finger on a phone is testimonial. That unlocks the individual's mind. It provides thought, a mindset, as opposed to simply giving the police officers additional data to continue their investigation.
It is. I believe that the actual taking of the phone and showing how to unlock it, the actual choosing which finger or which combination thereof is a testimonial act.
So if the police, if they had a warrant where, you had to give a handwriting sample, would that be testimonial? You have to move your finger.
I would, that would be my argument, that yes, that level should be considered as testimonial as opposed to the mere taking of a physiological sample.
How about fingerprint evidence or DNA? Because those have been held not to be testimonial. How do you distinguish putting a finger on a phone to unlock a phone as being testimonial and getting fingerprints when you're booked and comparing it to fingerprints at a site, which is not testimonial? What's the difference there?
The distinction, which I recognize I can't draw from a particular case, it would be the direct versus circumstantial nature of the two. There's never anything about a fingerprint that shows directly or when it was there, how it was left. Whereas this is direct evidence of your possession of this telephone.
In one case, the phone situation, it reflects what somebody's thought process is, whereas in the other situation, it doesn't. And to be fair, there's case law is split all over the federal district court level on this. It's split at the state Supreme Court level, almost equally. Case of first impression here in New York State Court. The U.S. Supreme Court denied cert in Payne, so we're not going to get any guidance from them anytime soon.
Right.
But this is a novel issue that is quite unsettled everywhere.
It certainly is, Judge. I respect the people's brief. We both, I think, tried to find any relevant case law that we could, and it does reflect that this is a very much a first impression for this court.
Can I ask you one last question?
Sure.
let's assume that we agree with you, there's a Sixth Amendment violation and the suppression motion should have been granted. What evidence particularly gets suppressed? The defendant is asking for the contents of the phone get suppressed.
Yes,
That's the incriminating evidence here.
correct.
Not the only incriminating evidence, it's just Conti said, but it is the main evidence. They had a warrant to search the phone, valid warrant to extract all that data, regardless of whether the defendant helped them unlock the phone.
Correct.
They'd go in there. So would not the remedy simply be you suppress evidence that his fingerprint unlocked the phone to the jury, or is it more broad like you asked?
I believe they would have to go back and see, again, there's technology exists which may allow them to bypass that security feature and get into the telephone. I believe that actually is part of the first point, which is obviously a lesser point, but that they frankly needed a second one. They had access and opportunity to seize every electronic device from that property. And that they actually should have had a second amendment or a second warrant that actually specified which of those phones, gaming devices, computers could actually then be forensically analyzed.
So perhaps it should be remitted to determine what the remedy would be if the panel were to agree with you on the right to counsel on the Fifth Amendment issue.
I would acknowledge that it would not be unreasonable that there may be some factual questions about that, and the people should have that opportunity, but whether or not they could proceed or not.
Anything further?
No, thank you all.
Thank you. Ms. Hallenbeck, good morning.
Good morning. Amy Hallenbeck on behalf of the people. I think that the people's position here is pretty clear that the lower court's reliance on Payne and Elder was appropriate under the facts and circumstances of this case. As you've discussed, I don't want to repeat what's already been said, but our position is.
Counsel, let me back you up. The issue may not necessarily be the facts and circumstances, right? It's the warrant itself. The
Correct.
warrant authorized the officers to place the defendant's finger or thumb on the phone.
That's correct.
And is that compelling testimonial evidence by giving the officers the ability to manipulate the finger and move it to the phone?
I think the discussion that you had previously is a valid discussion. My statement in my brief that he acted voluntarily is based on the fact that they didn't grab his phone and grab his finger and put it on the phone. They told him there was a warrant that permitted them to do that, and in response, he then put his finger on the phone.
Right. That fact cuts against your argument, though.
Usually you would think
that the police.
It is, however, the fact in the case. I would submit that it doesn't under the Elder reasoning, because under Elder, the court in that case makes very clear, I believe, a finding that putting your finger on the phone does not make the non-testimonial act of putting a finger on a phone testimonial, because it leads to or potentially leads to incriminating evidence.
How about this?
You still have to get into the phone to get to, you still have to examine the evidence in order to determine whether or not it's incriminating. The ownership aspect is merely leads to the potential for that, because other persons could have access to that phone. The ability to unlock the phone does not necessarily connect what's in that phone to that particular person. That requires further analysis. And in this case,
Mr. Chase, counsel, let me ask you this, counsel.
Yeah.
Mr. Chase brought up passcode cases, and I believe he's correct, where if the police ask you, what's the passcode to your phone?
right,
Or your safe,
right,
or any other lock, and you say 1, 2, 3, 4,
right,
that's testimonial, right?
correct.
We can agree on that.
Under the
Right.
case law, yes.
So if you, instead of using a passcode or in addition to, you use a fingerprint to open a phone or your
Right.
eyes. Mr.
doesn't
Chase's
usually-
argument is that if passcode's testimonial, one way to open your phone using biometrics is testimonial. Well, if using the passcode is, then the biometric way is two. That's his argument. I'm not saying it carries weight, but how do you respond to that?
I would say it doesn't carry weight. That your finger is more akin to the key to a lock as opposed to a combination to a lock, or as to your DNA, or as to some other physical attribute. And the only way to make it testimonial is this convoluted, I would submit, somewhat convoluted argument that because the information inside the phone involves your mind and the use of your mind and your knowledge, that somehow putting your finger on the phone becomes testimonial. And they're two separate and distinct things. The finger on the phone is just like the DNA in your blood or the key to the safe. It doesn't make you have to relay to the police knowledge or information or thoughts that you have. They may be contained in that phone, but the act does not do that.
But counsel, didn't the Second Department in People versus Porter say that typing in of a combination to a safe was testimonial?
I think that would be akin to a passcode, more akin to a passcode than essentially what we're talking about here is a fingerprint. That's what opens the phone. That's the biometric. I mean, or I guess it also could be facial, but in this, limiting it to the facts of this case, it's putting your fingerprint on that phone. And it's no different than putting your fingerprint on the equipment that the police have to take a fingerprint when they arrest you or for some other purpose.
But then when you've been arrested, there's already probable, they have a basis to arrest you. And you're not self-incriminating. Can a search warrant itself give someone the right to force them to self-incriminate?
I would submit that the search warrant would give them the right to take the fingerprint, essentially. They have probable cause to believe that there are electronic devices associated with that person in that house that they have probable cause to believe has criminal activity on it. It doesn't give them the right to make him self-incriminate. The act of putting your finger on the phone is not self-incrimination. Because it's non-testimonial. It's your thumbprint or your index fingerprint or whichever print that it is. And once the phone is open, excuse me, go ahead.
Counsel, let me interrupt. Sorry.
That's okay.
In this case, when the defendant was arrested, he was holding that particular phone.
Correct.
Let's assume the defendant was arrested and then 2 weeks later, the police find a phone. And then under this warrant, they want to bring the phone to the defendant and say, touch the phone, or we're going to use your fingers and touch the phone with this warrant. Does that make it testimonial?
No, I don't believe so. I mean, I think they might have to get another warrant because I think it would depend on where they got that other phone from and how it tied into the situation.
So there may be a circumstance that the purpose of touching the phone isn't necessarily unlocking the phone like a key, but the reason you might produce the phone and ask the defendant to touch it is to link the phone to the defendant.
To establish ownership, correct. But I would submit that first of all, in this particular case, you already have that in a sense because he's standing in a hallway with the phone in his hand when the police get there. So you've already established a certain level of control over the phone. So it's nominal at most that he's also able to open the phone. You already have that.
I think you're commingling probable cause, which is Fourth Amendment, with the Fifth Amendment. I don't care if they have probable cause. I don't care if they have a confession. The issue is, can he be forced to incriminate himself? Separate issue. And it's a close one. It turns on whether this is testimonial or not.
Right.
In Payne, you're relying on Payne, but toward the end of Payne, they made it very clear that it was specifically on those facts where the police grabbed and physically forced the defendant's finger to the phone. They said, our opinion should not be read to extend to all instances where biometrics is used to unlock an electronic device. Indeed, the outcome here would be different, may be different, if the suspect independently selected the finger he placed on the phone. Because there's thought process. I could set up my phone to be unlocked, my pinky, any one of my fingers.
Right.
And just the fact that the defendant chooses the right finger is incriminating. It suggests I know which finger to use, i.e. testimonial, that's the argument.
I would submit that it's not incriminating because again, the whole fingerprint argument, I won't repeat myself. But if it is, the only thing, you already have probable cause to get into that phone as you discussed previously. So there's sufficient probable cause for the police to get in that phone independently. The fact that they used a valid warrant to get into the phone, I would submit would not result in suppression, but if it did, it might be only that evidence that when standing there, the defendant opened the phone. You'd still have the evidence that the defendant was standing there with the phone, and you would still have whatever identifying information links him to the criminal information that's in the phone.
Thank you very much, counsel.
Thank you.
Case number 24 is People versus Kevin Harvey. The appellant has submitted. Ms. Gray is here for the people. Going to our calendar. We will deem that submitted as well. Case 25 is People versus Thomas. The appellant has submitted.
Thank you, Your Honors. Elizabeth Dannon for the people. We will rely on our papers also unless the court has any questions.
Actually, since you asked, I do have a couple.
Yes, all right.
Want to settle in for a
Yes, I
minute if
will.
you could.
Will do. And Thomas. There we go.
So the defendant in this case pleads prior to indictment to a Superior Court information charging various sexual felony offenses.
Yes.
The plea agreement is 5 to 15. The defendant says, I'll take 5 to 15. The court says, I'll give you 5 to 15. The people are fine with 5 to 15. During the plea colloquy, if I understand it correctly, the defense lawyer says, I have a mitigation report I'd like to submit for sentencing. I want to give you some reasons why my guy's not that bad.
Yes, Your Honor.
The court says, well, this is an agreed upon plea, agreed upon sentence. You got to talk to the DA. You got to get them to agree. This is, in a sense, he says, as I interpret his comments, the trial judge, I'm bound by this 5 to 15. This is a plea agreement. Then he says, he does say, and I know what your point's going to be is, well, the judge says, well, I'll read it. You know, I'll read it. And then they go to sentencing, the defendant gets 5 to 15. The defendant's argument on appeal is that the court misapprehended its authority and that the court did have authority to go under 5 to 15. Do you agree with that point? The court could have imposed a different sentence. This is not a plea to an indictment. It's a plea to some reduced charges. Do you agree with the defendant that the court could have gone below 5 to 15?
I would have to look to see what the sentencing guidelines would be.
All right, assuming it's a lawful sentence to go to say 3 to 9.
Yes, Your Honor, I believe that the case law is clear that the court is the ultimate arbiter of discretion with sentencing.
It's like YO, People versus Rudolph.
Yes.
The people can say this plea is contingent on the court not giving them YO. The court can't defer, it has to make its own decision.
Yes.
This is the same thing, right?
Yes, Your Honor.
So the court here at sentencing did misapprehend its authority.
I do not believe so, Your Honor. I believe that what the court was telling to the defendant was that it would make its own decision at the time of sentencing, but that the sentence, the court, I put some case law in there about the defendant would be bound by his agreement. So the defendant was trying to negotiate basically with the court to agree to a lower sentence. But the court was saying you have to agree to be bound by the sentence. So if you want a lower sentence than what we're looking at here, you would have to speak with the people to try to.
But I thought you just said that that's not correct. The court could impose a lower sentence. It's not bound.
Well, Your Honor, we would say that the court law says.
My understanding of it is, and maybe I'm wrong, and we do have post-argument submissions, but the case law says, just like a defendant, if a defendant pleads and gets a promised sentence from the court at sentencing can impose a higher sentence with the understanding that the court would have to allow the defendant the opportunity to withdraw the plea. That's not what he agreed to. My understanding is it's the same the other way. is that if the court wants to give a lesser sentence, and it's not a plea to the top charge, not plea to the whole indictment, then the court can say, look, I'm going to go 3 to 9 here. And the people would then have the opportunity to withdraw, to have the plea vacated. That's my understanding. It could be wrong, but what's your take on that?
Your Honor, I would agree that the court can, I'm sorry, I'm trying to find here. I had 3 cases today, so I'm trying to find the correct one. I'm not finding it right now. That yes, the people can withdraw their offer if the court refuses to go along with it. Here, I believe, though, that the court stated reasons during its sentencing for why it imposed the sentence. You know, it spoke to the multitude of young women there that were scarred for life. And it imposed a sentence within the guidelines, and it is unpreserved as well, which the case law says issues such as these must be preserved. And there, the defense counsel actually thanked the court for its.
I'm not suggesting that. What the remedy here would be to remit it for the trial judge. He's going to read the report. If he didn't before, he's going to give him 5 to 15. Okay. I'm not saying it's going to go anywhere, but just this principle, it's hard for me to agree that it's hard for me to disagree with the defendant that the court didn't understand its sentencing authority here based on what the court said is I'm bound, you're bound, talk to the people.
Okay.
Doesn't sound to be right, Mr.
Counsel, if the court did indicate its sentence that it did review the mitigating.
It did. It listened to the.
At sentencing itself.
Yes.
So would that be determinative here in terms of whether the court understood its ability to deviate from the negotiated sentence?
I believe that the court did review the mitigating materials, and also the defense attorney repeated them for the court's consideration during sentencing.
So it may have been an inartful statement.
Yes.
Earlier, but it doesn't necessarily mean the court
did not consider. Reading through the record, Your Honors, I wish that, obviously the waiver of the right to an appeal was grossly insufficient. I wish that the judge in this case had expressed its reasoning more thoughtfully and gone, expressed its thought processes a little much better than what it did. But I do not believe that on this record, it is apparent that the court did not recognize that it had the authority to impose the sentence. And so.
Thank you very much.
All right, thank you.
Case 26 is People versus Sanders. That case has been adjourned. Oral argument on motion and consent, I believe.
Yes, Your Honor.
So we will be in touch with both sides with respect to the rescheduled date.
Thank you, Your Honor.
Case 27 is People versus Rodriguez. Good morning.
Good morning. May it please the court. Allison McMahon on behalf of Appellant Indalecio Rodriguez. I'll be focusing on point 1 of my brief today. The evidence here consisted of a single witness cross-racial identification that was unreliable, and the circumstantial evidence did not reasonably or logically compel guilt. Here, there is an argument that the people probably proved that he was guilty, but that is not enough. The people had to prove beyond a reasonable doubt the identity of the shooter in this case.
Didn't Mr. Rodriguez identify, the victim identified Mr. Rodriguez on 3 occasions?
He identified him in a photo array, and then at trial again, yes. However, that identification was not reliable, and Ferguson himself was not a credible witness.
Well, he saw him on the street, right? When there was the argument, he came.
Yes.
At behest of
Very
his
briefly.
other friend. You saw him?
Yes.
All right.
So earlier in the day,
for as much as 10 seconds, didn't
he? It was about a guess. He was driving by, and when he did see him, he wasn't.
He got out of his car and was arguing with Mr. Rodriguez. And then Mr. Rodriguez got in his car and pulled away, but he was still looking at Mr. Rodriguez at that time.
My understanding of the facts is that Ferguson did not interact with Mr. Rodriguez earlier in the day whatsoever. He drove past him, and by the time he got to Evans,
He got out of his car.
Mr. Rodriguez was getting in his car to leave.
He saw him getting in his car and he's arguing. You can see him arguing with the individual.
Yes.
And then he backed away and pulled up and he's still arguing with him. The individual in the back, I can see him arguing with him.
Yes, my understanding is that he was driving past, and when he was driving past, he looked over and saw Mr. Rodriguez on the sidewalk, but he was looking for his friend Evans, who had called him, who was in the argument with Rodriguez.
Okay, all right, but basically the video shows that he's arguing with Mr. Rodriguez. Then the second occasion, before he was shot, when Mr. Rodriguez walked past his car,
Yes,
he saw him.
yes. However, I think that
That's the second time you identified.
the shooter there had his hood pulled up very close and tight to his face. Ferguson testified that he was on his phone. He briefly glanced up and then went back to his phone. Neither occasion that he saw the earlier occasion when he saw Mr. Rodriguez and when he briefly saw whoever was walking past his car, he wasn't focused on that person. He
That
was
was a question for the jury to determine whether or not this identification was sufficient, correct?
Yes, however, I think this is a case where his testimony was incompatible with other witness testimony. He contradicted himself multiple times throughout it. And it's the type of case where this court can sit as a second jury and look over and assess the credibility. And I think that here his credibility falls very short.
Why would he, is it reliability or credibility? I mean, why would he lie? This guy shot him. Somebody shot him for absolutely no reason, almost killed him. He would have every incentive to identify the person who shot him, not just somebody random who didn't shoot him. So you're not saying he's not credible, Mr. Ferguson. You're saying just in the height of the moment with the stress, cross-racial ID, it's just not a reliable ID, right?
My argument is that, it's not a question of whether he lied or not. It's a question of whether his identification was credible and reliable.
Okay. And you mentioned the need for the dangers associated with cross-racial identification. I watched the video many times. The victim is African-American, correct?
Yes.
The witness the defendant is, his last name's Rodriguez. He's described as Hispanic, but what race is, I mean, you can have you can have Black Hispanics. Well, I mean, his photograph, I'm not sure what he is. Where in the record does it show that he is not Black?
I think throughout the record, it is assessed at least that his mother is Puerto Rican and his father is Dominican.
But does that dictate what color you are?
I don't believe that necessarily falls into the cross-racial. I mean, the fact of the matter is that they are of two different races.
What race is your client?
He is Latino.
Okay, and maybe I'm making, I don't know. I looked at the photograph and are there not, well, we'll move on to the next issue. Some other issue here in this case, but I understand your point. This is close. There is some evidence. I watched the video the same way Justice Montour did. The first interaction was not him just driving by. Mr. Ferguson got out of the car, walked back, was seen by your client on the porch, continued to see him, and your client got in the car and drove away. There was a lot of interaction there. It wasn't just a drive-by. But as you say, this is based really solely on his eyewitness, and that's where we see most wrongful convictions are cases like this.
Yes.
And so we will take a really close look at it.
All right. If there's no other questions, I can press on my papers.
Good morning, Your Honors. If it may please the court, Mindy Van Leeuwen for the people. As Your Honors have already sussed out, there is sufficient evidence here to prove beyond a reasonable doubt that this victim did identify his shooter, the person who shot him 5 different times, some of those at close range, just from the passenger side of the vehicle. As Justice Lindley and Justice Montour had correctly deduced, there was a period of time, even if it was brief, the 5 to 10 seconds, upon Mr. Ferguson's arrival at the scene where his friend, Mr. Evans, had been having an argument with Mr. Rodriguez. At that point, I don't believe there's any testimony that Mr. Rodriguez and Mr. Ferguson had the argument themselves, but Mr. Ferguson did have the time to see who was arguing with his friends and observe him on the street and observe him get into the car and go. The second time was when he saw him nearly 2 hours later, after the defendant had threatened to shoot up the neighborhood, shoot the mothers of Mr. Rominski, if I'm pronouncing his name incorrectly, and Mr. Evans. And he said he's coming back to shoot up the neighborhood. 2 hours later, he does just that. He comes up on a nice day with his hood tied around his face, as Mr. I believe Lori says, Mr. Ferguson's cousin, who also views the shooter, and says, I looked him in the eye. We didn't have any problems, so I kept texting, and less than 5 seconds later, he crossed in front of my car and started shooting into the passenger side. The video, the direct evidence corroborates that testimony. Whoever the shooter is, which is obviously the defendant, does.
Obviously, it's a little strong.
I apologize. Beyond a reasonable doubt, we've proved that that person is the defendant because the direct evidence corroborates our one witness ID. Okay. I would also state, Your Honors, that Mr. Lori does say that the build of the shooter matches the defendant's build. So we have corroborating testimony there along with his height. I'm going to butcher this poor person's last name, Bergersen, also says the same thing. The shooter is the same height as the defendant. That was established through Detective Sterling's what the defendant's height was. Mr. Bergersen also said there was a light-skinned male shooting at a dark-skinned male. So he's identifying that someone is a little bit less, I don't know how much lighter skin, we're not going to hypothesize about that, but that's consistent with the defendant shooting after Mr. Ferguson, who got shot in that situation. All of the evidence corroborates Mr. Ferguson's testimony. There is nothing inconsistent about Mr. Ferguson's identification of this defendant. There is minutia in the details that is where poor Mr. Ferguson, who's lost pints and pints of blood after being shot 5 times, is at the hospital and says, I don't know, he thinks it's one detective versus the other, and he doesn't remember what day he sees a photo array. I think it would be hard pressed for anybody after they've lost pints and pints of blood that's on medicine for intense pain medication, who's going into reconstructive surgery, to remember what day he identifies the defendant. That's the minutia of the case, and that's something we don't need to worry about. It's that he knows who shot him, and even though he's unsophisticated and perhaps in how he speaks, which was repeatedly pointed out at trial and in defense's brief or appellant's brief, that doesn't make him not know who shot him in this case.
The photo array testimony came in, that evidence came in at trial, right?
That's correct, Your Honor.
The photo array was not in the least bit suggestive. I mean, they were remarkable. They look like almost twins, everybody in there.
I had trouble telling them apart, quite honestly. And what makes that more compelling, besides that it was a double blind, where, I'm sure you all know what it is, but one officer doesn't know anything about the case who's delivering that. And there was no one else in the room when Mr. Ferguson was identifying that person. He identified the defendant within 5 seconds and said, that's the guy who shot me. This was all over a parking spot. He knew exactly who it was, and he knew where he knew him from. All of the facts in the case point to the same direction. Beyond a reasonable doubt, this is the defendant who shot him. If you have no further questions at this time, I'll rest on my brief. Thank you.
Case 28, matter of Liliana S. We have submissions from everybody but the attorney for the children. Mr. Muldoon is here and Ms. Gray is virtual. Should be virtual. Bear with me a second. And she is there, so Muldoon, good morning.
May it please the court, Gary Muldoon for 3 of the children. In this case, the mother defaulted at the dispositional hearing, and the trial judge had notified her 3 times before of her need to appear and that the hearing would proceed in her absence. On the hearing date itself, the case was adjourned from morning to the afternoon for her appearance. Neither she nor the father, who is not party to this appeal, showed up. Her attorney placed on the record as did the father's attorney, that the attorney was intentionally not participating in the hearing to preserve her client's future rights. I submit that in this case, the judge acted properly in the advisements beforehand and the morning of the hearing and in proceeding with the default hearing. And I further submit that the judge acted properly vis-a-vis the mother's attorney. There is an issue that is raised by the appellant in this case of whether the judge had directed the mother's attorney to not participate. The judge in no way did that. In no way did that, as best I can tell from a fair reading of the testimony here.
The lawyer was, it was a sound decision by the lawyer not to participate, was it not? It preserved the mother's rights to move to vacate.
Yes. And I don't think a judge has any right to do so. And the judge did not overassert her authority. Judge Sisson did not do so. So to the extent that there is case law that would suggest otherwise, and that there's a third department case called Michaela that could be read somehow to support the position here, it's factually completely different from this case because the judge here did not restrain in any way the mother's attorney from participating in here. She made the strategic decision. It may have been a wise decision on her part to preserve her client's rights. Based on that, there was a plenitude of testimony here, I believe, by 3 different DSS witnesses to support the judge's ultimate finding. So based on that, and there's a fourth department case law that supports this position, cited in my brief, including matter of Lewis R. from 1992. With regards to the status of the children, I represent 3 of the children. One of them is living in Victor, New York. The other 2 are living together in Florida. All are in foster care. They appear to be doing very well with prospective adoptive parents.
Thank you, Mr. Muldoon. Ms. Gray, good morning.
Good morning. Thank you, Your Honors. I represent 2 of the children, the 2 oldest, Liliana and Elijah. And I would concur with Mr. Muldoon's argument regarding the support for the lower court decision, as well as the actions of the judge. Just to update the court on my 2 clients, Liliana is in a residential placement near Albany. She's doing very well. She's struggling with some substance abuse issues, but is progressing. My younger client is in the same foster home as one of Mr. Muldoon's clients. And if we could clone these foster parents, Judge, I'd do it in a heartbeat. They cooperate with the grandparents in Florida who have the youngest children. They take the children up to visit Liliana at her facility. Elijah is doing extremely well in their home, and they plan to adopt. Barring any questions, I would rest on my brief.
Thank you, Counselor.
Thank you.
Case number 31. I'm sorry. Yes, thank you, Justice Montour. Case number 29. Landhauser versus Landhauser Myers. We have Mr. Otis is virtual, as is Ms. Davis. Mr. Steinberg is here. Good morning.
By the way.
Yes, yeah, I knew I was butchering that in the process, so my apologies to the parties if they are watching from home. Mr. Otis is here. Ms. Davis, we are waiting on. All right, good morning. Mr. Otis, you may proceed.
Thank you, Your Honors. I'm here on behalf of the appellant mother. I'm certainly not here today to argue that my client is a saint, but she loves her boy and she would like to raise him. She is the child's mother. She's raised him most of his life, and she hasn't done anything that justifies losing him in the way that she has. The mother has repeatedly acknowledged that she has had problems with alcohol abuse. She maintains that with the help of various programs and therapy that she has stopped using alcohol. But importantly, being an alcoholic is not an extraordinary circumstance that deprives a parent of custody. Neither is a DUI, nor are a couple instances of a child running to a neighbor's house because mom's mad at him.
But weren't there acts of violence against him too on occasion?
Well, the
By
custodian's
the
brief,
mother? I'm sorry.
well, I think most compellingly on that regard is the custodian's brief makes much of an incident of the police noticing a bite mark on the child's thigh at the neighbor's house. Importantly, this was not an injury that the child attributed to his mother in the record anyway, nor is there anything in the record stating that the mother bit him. The mother states she never saw the bite mark and she's never been shown a photo. She says she has no idea how it happened. I think from her perspective, it's at least equally plausible that the child in his fit bit himself in frustration, as kids do. The standard for awarding custody to a non-parent is a demonstration of unfitness or persistent neglect or abandonment or other like extraordinary circumstances, and there's not that showing here. But Your Honors, the gravest injustice of this case, in my opinion, is how the trial court structured visitation for the mother. The court authorized visits only as the custodian might agree, with no schedule in place requiring visits. As I understand things, she has not yet agreed. It's been years. Respondent's brief concedes that, quote, "There's no doubt that this has worked out in a way that has kept mother and child apart," end quote. So the widow of this child's grandfather has accomplished an effective termination of the mother's parental rights the way this order is set up. And this court ought to be...
Counselor, if I can interrupt you on the visitation, the court said that the parties shall mutually agree to a schedule. There wasn't an exclusive authority granted to the custodian, as you call the step grandmother here. And then doesn't the mother have the right to petition the court if the step grandmother is unreasonably withholding the child?
Yes, Your Honors, and by conditioning it or making it a mutual agreement necessary instead of setting up a specific schedule, he has effectively given the step grandmother, as you call her, veto authority over any visitation. And there are proceedings pending in the court below because she hasn't gotten any. So, and it's been a long time. And effectively, this amounts to a termination of her rights unilaterally by this step grandmother who just withholds agreement. This court ought to intervene and restore this mother's custody of her child, or at the very least order that she be given a schedule of regular and frequent contact with her child. And if there's nothing else beyond that, I'd rest on my brief for the legal points.
Thank you, Mr. Otis.
May it please the court, Michael Steinberg for Cindy Lochnauer, who is the widow of the grandfather, and not the custodian. One of the problems with this case that the trial judge found is that the mother takes no responsibility for her actions. And I'm hearing that from Mr. Otis, who now says, well, the bite marks, maybe Liam bit himself. Maybe he bit himself, and you can see where these are on 261 and 262 of the record. Apparently he bit himself on the leg and he bit himself under the armpit. There is a lot here. There is an incident with a hockey stick. There is the time when this woman was completely out of control. This child loves his mother, but is terrified of her. He gets nightmares when she calls. I'm not saying that some supervised visitation might not at some point be good, and it would be nice if things were to get better. But this is a very difficult situation. The trial judge did its best. It is, I might add, not a proceeding under the domestic relations law. It's a Bennett v. Jeffries case. And the law on this is quite clear. We're looking for extraordinary circumstances through a totality of circumstances test. To isolate, oh, there are only 11 months in which Liam was with his step-grandmother, misses the point. There is a large pile of the circumstances here.
Well,
not only that.
The mother said a number of times, I'm not going to use her language, but how she referred to the little boy, she didn't want him. She said that multiple times.
Yes.
That seems to be extraordinary. We don't see that a lot.
No, it's and in fact, that combined with the constant reliance that the mother had on my client to look after the child is telling as well. This court has fairly limited review powers here. The decision below should be upheld as long as it's based on sound and substantial evidence. And in this case, the sound and substantial evidence turns very much on questions of credibility. And that is something to which generally appellate courts defer to the trial court. There is really, I mean, this is a really sad case, and there's absolutely no evidence in the record that does not come from the mother that indicates that my client is not hopeful at some point of getting Liam back with his mother. We want to do this. It's just not been possible so far because Liam is so traumatized.
Is there any visitation going on mutually agreed upon?
As far as I know, the attorney for the child can speak to this. As far as I know, it's not. And as far as I know, there is a proceeding in family court to try to resolve the visitation issues. That is outside here. I don't think there was anything the least bit wrong in the court's visitation order here.
Could that possibly render moot part of this case? If there's a petition for visitation and he's saying the challenge in visitation here, might that one contention become moot?
The visitation contention would arguably become moot if that's resolved. But the step grandmother's custody would obviously, and that's what is important here. There is no other way to keep this child safe. I think for the rest, I can rely on my brief, unless there are any questions.
Thank you. Ms. Davis, good morning.
Good morning, Your Honor. Stephanie Davis, attorney for the child. I think I will go to the questions with regard to current proceedings in the family court. I would like to state that the court has ordered the mother to call on Wednesdays and Sundays, and she did miss the first 2 times. The court did subsequently order visitation for December for 3 different days in a row. She called on the first day and canceled. The next court ordered visitation is set for January 20th, 21st, and 23rd at the Resolution Center. And I'm sorry, go ahead.
Yeah, we're getting a little far afield of the record, but the point is that the visitation issue is being currently litigated. Well, it sounds like there's an order, at least temporary order in effect right now, right?
Yes, there is, Your Honor.
Is that permanent order or temporary? And I'm only asking.
I can't answer that, Your Honor.
Right.
I just know that the next visitation, he's ordered 3 days in a row, 20th, 21st, and 23rd at the Resolution Center. And I only brought this up, Your Honors, because Mr. Otis approached the topic here.
No, absolutely. And I understand, and I appreciate you do bringing it up because it's relevant to the mootness issue on his visitation contention. If the visitation issue is being resolved, then perhaps it's something that we need to address here, but that still leaves the issue, the main issue of custody. But in any event, anything further you want to add to the?
Well, I just wanted to emphasize that Mr. Otis's and the appellate's reading of this record is just totally off. I mean, the mother engaged in gross misconduct and behavior that I think threatens the life of this child. And I think that there's real jeopardy here if this child is returned to the mother. I mean, she drives while intoxicated with the child. She says she does not have an alcohol issue, which, by the way, the testimony of her own husband contradicted that. She attacked the child with the lacrosse stick. She verbally berates him with profanities for no discernible reason. And it is true that he ran out of the house in the middle of the night in the winter, half dressed, saying, "Help me, help me." She calls him obscene names, and Your Honor alluded to one of the names that she calls this child. There's the bite leg on the mark on his leg. And Your Honors, she went 300 days without seeing this child. And that is her own testimony. And to that particular issue, I refer you to your own case of Torres, and where the father was absent for, I think it was 8 months, that he took no steps to become part of his child's life. And in that case, you also had domestic violence, and you found extraordinary circumstances in that matter. I think Mr. Steinberg was correct in that the mother habitually calls the grandmother, "Please come and get him. I do not want him anymore. I would like to get rid of him. He is a, quote, little effer." She does not take responsibility for her actions. She has not learned from her, learned skills from her anger management classes, her parenting classes, and her mental health counseling sessions. And matter of fact, in the record, she stated, "I do not need alcohol counseling. And if I do, I can enroll in classes once I move to Washington State." I tell the court here that the grandmother has always been a part of this child's life. Matter of fact, she and her husband pretty much raised this child from the time that he was born, because the mother was in a job that took her out of state. So it was years that this child was in the grandmother's custody.
Yeah, I think we're starting to get the picture. So
thank you, Your Honor.
we appreciate it, though. Thank you very much.
Thank you.
Thank you. Case 31 is Kenyon versus Nicoletta. The appellant has submitted. Respondent is remote. Counsel, good morning. Your opponent has submitted. If you want to unmute, you may begin.
Good morning, Your Honors. The family court below properly found both extraordinary circumstances and that my client's best interest would be served by continued custody with the paternal grandmother. Unless this court has any questions, we're seeking an affirmance, and I'll rest on my brief.
Well, I thought you were seeking dismissal.
I am under point 1, Judge. I did argue for dismissal. I misapprehended the rules for the.
I'm sorry. Did you misstate the rules, you think?
No, I don't think I misstated the rules. I misunderstood the rules for a supplemental appendix submission. Therefore, it wasn't accepted. So the document that I had was not attached as supplemental, but my legal argument does remain. Just looking at the dates of the court decision, the date of the attorney's signature, and then 2 days later is the date of the affirmation attached.
The notice of appeal here was not filed within 35 days.
Correct, Judge.
Service of the order entry. And that seems clear. So if you're right on that, we would dismiss the appeal. We wouldn't affirm it. Now, isn't it moot in that the child has been adopted already?
The child was adopted through a proceeding in surrogate's court with a different attorney. Yes, that adoption has been finalized.
Even if it were timely, if a child's been adopted, that there's no parental rights here to assert. So it's moot. It's just a question of which basis we dismiss it on. There's a lot to choose from here.
There
One,
is,
it's
Judge.
timely. Two, it's moot because the child's been adopted. So I just want to make sure you weren't backing away from your untimeliness argument.
No, Judge, I'm not. Point one, I think is a valid argument, and I think Mom mounted her appeal too late.
But thank you very much.
Thank you, Judge.
Case 32, Francisco R. versus State of New York. Both lawyers are arguing remotely. Mr. Riley, good morning.
Good morning, Judge. Can you hear me?
We can.
Very good. Good morning, and thank you, Presiding Justice Lindley, Nate Riley of MHLS on behalf of FR, and may it please the court. I appreciate the court's time this morning. I will be brief. The decision of the lower court was against the weight of the evidence, where it found support only in loose, equivocal, or contradictory evidence personified by the OMH doctor's testimony that FR remained likely to commit another sex offense, despite his own actuarial assessments indicating no more than a 30.6% likelihood of recidivism. The statute deliberately—
Hasn't that percentage gone up since the last review? Last review was 26%, so isn't he going the wrong direction?
Correct, Judge. We would still argue that the statute deliberately chose the word likely to commit sex offenses, and the actuarial scoring in this particular case simply does not support the conclusion that FR remained likely to commit a sex offense.
Well, didn't both experts agree that that petitioner was predisposed to commit sexual offenses, and the various tests deemed the petitioner well above average risk of reaffirming? Both of the experts indicated that.
Right. And so our argument is essentially that well above average risk does not equate to likely.
Isn't your claim that, well, he's 65 years old and basically at that age, the desire to commit these acts is reduced. However, percentages say otherwise, experts say otherwise.
Well, in part, Judge. So yes, age was a dispositive factor here. That's certainly part of our argument. However, we would not agree that well above average risk equates to a likely in the way that term is used in the statute. We have
Did he tell the therapist that he would rape as many as he could and kill as many?
I believe that was part of a hearsay statement that would be Floyd Y material from several years past. Your Honor, that was not part of the hearing in this particular review. We have a lot of respect for the representatives in Albany, and they explicitly stated that confinement should be reserved to only extreme cases involving the most dangerous offenders in order to protect the public from recidivist conduct. And that's in section—
Doesn't he refuse to engage in treatment as well?
I'm sorry, Judge, I couldn't hear what you said.
Doesn't he refuse to engage in treatment?
So there's 4 different points that are raised by the respondent in their brief, and that's one of the 4 that I'd like to address this morning. So in terms of the state puts forward a record that he was insufficiently progressing in treatment. We would concede that Dr. Haddon had testified that he had made minimal progress in treatment, but that participation that he did undergo showed the independent examiner that despite his ASPD diagnosis, FR does exhibit an ability to comply with rules, and that's on page 126 to 127 and 130 of the record. In addition, the OMH doctor admitted that FR had recently sought and participated in maltreatment prior to the hearing. That's at page 66 to 67 of the record, which is something that the independent expert also acknowledged at page 125 of the record. So we think that the record that's put forward, the record tells a much more complicated story than respondent puts forward in their brief. As to a history of resisting supervision, the last time that FR was in the community was in the early 1980s, mid 1980s. When he was in his 20s, more than 4 decades ago. And so the only thing we have to gauge how he would do in the community currently is what he has done while confined. And since that time, he has had 1 incident in 2007, which I believe Your Honor was referring to earlier. And he has had no sexually acting out thereafter in roughly 16 or so years of confinement. And
I think the court indicated he is making little progress. And also there's evidence that he's had physical altercations with his peers.
There was certainly an indication that there's been physical altercation with peers. However, that the statute and the specifically looks at sexually acting out, which was not occurring in this case. And it looks at a likelihood to commit another sex offense. And so those acts of physical aggression would not speak towards that. And that was specifically addressed during the independent examiner's testimony concerning psychopathy and why the PSLR should not be used in this instance for somebody of his age, because psychopathy stops being a predictive of violent recidivism for older individuals. And that's at page 88 of the record, and is detailed by 3 peer-reviewed articles that were received in evidence. Essentially, the PCLR lacks predictive power for elderly offenders, according to the independent expert. And so he did take a look at some of these very problematic behaviors that your honor is describing, and still recommended to the court as the independent examiner that the individual receive cyst as opposed to being found DSORC and his confinement continuing.
Mr. Riley, anything further?
Yes, Judge. So as the independent examiner opined, FR is simply no longer dangerous in the way that term is used in the statute, as evidenced by nearly 17 years of not sexually acting out. And again, that's within the order at page 16. It's in the testimony of both doctors, pages 73 to 76 and 100 to 101 of this record. Despite his confinement in docks or Stark for the past 17 years, he has not, during that period, acted out sexually. And therefore, we ask this court to reverse and remit for the implementation of a regimen of cyst for the 66-year-old lacking any record of any offense or sexually acting out for the past roughly 17 years. If there are no further questions, I thank the court for its time.
Thank you, Counselor. Mr. Lessignan. We can't hear you, although you are muted. I'm not sure what the problem is there. Yeah, we still can't hear you. Nope. Can't hear you still, and not sure what the technological issue there is. I know you have AirPods on. I don't know if there's an issue with the AirPods.
That was going to be my suggestion, Your Honor.
Yes.
I've had that problem.
He might be connected to your AirPod rather than to the computer. Yeah.
Your Honor, if he selects audio in the bottom left corner, it should show which microphone is connected.
Counselor, did you hear that? If you select audio at the corner there, might be of some guidance. No, we lost you altogether. Yeah, this is heading toward a submission. To be honest with you. Well, here it is. Yeah, so tell you what, though, the good news is that you have a very comprehensive brief that we have read and will read again. So, and we do have post-argument submissions if there's anything you want to address. So we appreciate your time. Thank you.
Thank you, Your Honor.
Okay. Case 33, DeMarco versus Severance. The appellant has submitted. Mr. Steinberg is here to respond.
I will do my best to be brief. This is what I hope is the last gasp of a protracted and extraordinarily vicious litigation. Court's already dealt with part of it. It is apparent even from this case where the slurs, which were really a campaign of character assassination against Mr. Severance, are clearly irrelevant to the issues before this court. As far as the actual issues, we submit that there's no abuse of process here. We cited a couple of cases that said the mere issuance of an order of protection is not abuse of process. There has to be some perverted use of it. And there's an extraordinary amount of bizarre arguments that somehow this is interfering with the grandparents' right to visit with their grandchildren, which is a right they do not have.
Right, we understand the argument that with respect to the guns, that's the intended use of the order of protection.
Yeah.
And it's not perverted, and it's not the abusive process cause of action isn't stated by filing a lawsuit improperly. It's getting an order or some legal process and using it for some other purpose for which it was intended. You say that's not the case here. You want to briefly address the malicious prosecution?
Absolutely.
Which it sounds like it may turn on damages there, special damages.
That is the issue. This is a malicious prosecution case in the civil context. And under CBS v. Engel, there has to be special damages.
Taking his guns ever so briefly, depriving him of property, I think is the slim reed they're holding on to there.
They're moving to something else. They keep arguing, well, I had to pay attorney's fees, and CBS v. Engel says attorney's fees are another head of damages. But what the Court of Appeals said there is basically, okay, attorney's fees aren't special damages. But if you're having to defend a frivolous lawsuit, you can get attorney's fees, so you're not entirely without a remedy.
Yeah, we've seen that issue before. If attorney's fees are special damages, then they're not so special because almost everyone pays an attorney.
Exactly. And the same thing with missing work.
But again, it comes down to, due to the order of protection that Mr. DeMarco claims was obtained with false allegations. We have to assume that they're true, right? At this point, we have to assume that your clients lied about him in those petitions. And there's an order of protection. So the grandfather, he loses his guns for a while. He gets them back.
Mhm.
Is that special damages? That's really, would you agree that's what we have to decide? I mean, look, I'm not saying how much that's going to be worth monetarily if he gets the trial, but is that enough to get him to trial? Is that enough to not get him to trial, but to state a cause of action?
For one thing, I think that they don't really rely on that in the malicious prosecution branch. They rely on it primarily in abusive process. Malicious prosecution, these statements are privileged, and these statements are the statements on which the order of protection was granted are statements of fear. There is no lie in saying, I'm afraid these people might do something with their guns. It may well be wrong, but the question is not, am I lying about their doing something with the guns, or am I lying about their fear? In an ex parte proceeding, this often happens in orders of protection. You err on the side of caution. You say, take the guns, let them come back, let them explain why I'm wrong, and if I'm wrong, they get their guns back, and that's what happened. That's not actionable malicious prosecution. That's not the commencement of a proceeding for perverted bases in order to injure somebody that results in special damages.
Unless you know how the person feels about their guns, and so you do that so that their guns can be taken away from them.
I'm not sure I would like our courts to be looking into the subjectivity of that so clearly. Is it malicious prosecution if the other person loves their guns, but it's not malicious prosecution if they have just, they use them to keep down the number of pests on their farm and they have no emotional connection with them? No, I think that the test for special damages under CBS v. Engel is a fairly strict one. It has to be something out of the ordinary, not the sort of thing that normally happens in litigation. There are no special damages here. Certainly not the fact that Mr. DeMarco couldn't work while he was doing this, while he was engaged in the lawsuit. Certainly not in the fact that he had to pay attorneys. He, in fact, was appearing pro se. The mere temporary suspension of the right to have firearms, which is, after all,
which is a constitutional.
It is a constitutional right.
Maliciously.
But it is not a damage in the sense that malicious prosecution cases
But
talk
it
about.
may be a special injury.
Once again, if it's a special injury, and if it's a special injury because of some special attachment to the guns, I question whether that's someplace courts want to go. But the question goes back to what is the basis for that relief in the order of protection? And, you know, we get back into questions of privilege. Once you start talking about, well, there were lies in the papers, so we can go after that. What about the things that are being said about Dominic Severance? He says they're lies. Why couldn't he then go after the DeMarcos for saying these horrendous things about them?
And again, this is just a motion to dismiss, right? We're at this stage.
The motion to dismiss, but
And they're alleging that there's a special injury, there's loss of property here, with their guns and that, is that enough to carry the day?
This is, once again, the argument in malicious prosecution is couched in terms of loss of income and attorney's fees.
Well, it's also, I think, expresses it more so, not just that, but loss of property. And the property here, whether there's a special injury, there's an allegation made in the complaint, which we have to take as being true and give them the benefit of the doubt.
They can't simply say loss of property. They have to say something specific. And the specificity here would have to be loss of the use of firearms for a period of about a month.
Or it could be, I think Justice Montour's point doesn't necessarily have to be guns. It could be loss of baseball cards or loss of my wagon or anything. But look, it would seem like we'd be doing everyone a favor, including the plaintiffs, to dismiss this, to put an end to this, but we can't do injustice to the law. That's a problem. And we gotta show fidelity to the law as much as this. The only people who are making out on this dispute over all these many years are the lawyers. Nobody's gotten anywhere. The ball has not been advanced by either team down the field.
In fact, the underlying dispute has been dismissed. The grandparents withdrew.
Yes.
That's outside the record, but I think I can say that.
Well, we can take judicial notice. We heard it.
But no, the issue, even if there's a claim, I would dispute that the minor inconvenience of losing the use of firearms for a month constitutes special damages for malicious prosecution. But the question still has to be asked, is what the severances did improper in the first place? And because you have to bring these cases for improper purposes. What we don't want, the whole purpose of the limits on malicious prosecution cases is what we don't want is for meta litigation. We don't want people who lose then bringing another action saying, okay, people who win saying another action saying, I had to do this because you lied about me. And then if they were to lose on that, the prevailing party would say, I wasn't lying about you. I can bring a malicious prosecution case for you, against you for bringing a malicious prosecution case. The public policy behind the restricted nature of malicious prosecution is to make sure that the way to the courtroom door is not paved with landmines. That's why statements and pleadings are privileged, and they're absolutely privileged. They're not qualified privilege. There's no qualified privilege here. It's an absolute privilege, as long as they are material and relevant. And unless there are other questions, I will say that the statements that were made in the severances papers were material and relevant because we have no reason to think that Ashley Severance wasn't afraid of what her parents would do in defense of her or to rescue their children or whatever. So that's material and relevant. No matter how you look at privilege, it applies there. But the constant statements under oath about Dominic Severance's sexual nastiness and abuse of the woman who is now his wife and so on, none of that is material and relevant to the malicious prosecution case, the abusive process case, or anything else. Those are arguably not covered by privilege. And it's just that kind of imbalance that makes me argue that we need to maintain the narrow limits on kinds of actions that chill the right to go to court.
Thank you, Councilman. Case number 34 is Bauman versus Bauman.
Good morning. May it please the court.
Do we have two appellants here?
We do. So it's up to you all. Who would you like to go first?
We're waiting. We have a respondent, Mr. Donahue, who's supposed to be in court this morning. Oh, all right. You're the respondent or you're both appellants. I got you. Okay. My apologies. Submitted. Okay. Thank you. You are correct. And I apologize. Counsel, you may begin.
Thank you. My name is Steven Salcedo and I represent the appellant Dennis Bauman. I'd like to rely primarily on my briefs. I think they set out the issues pretty clearly, or at least I hope they do.
They do.
But I'd like to just say something very quickly about illegal eviction first. And I just want to emphasize some of the language in RPAPL section 768. And that section is one of the several that makes, that sets out illegal evictions, that describes illegal evictions. And it even specifies particular examples of illegal eviction. And one of those is removing the occupant's possessions. And Margaret, in this case, leans into the fact that she did remove my client Dennis's possessions from the residence on November 18th. And the sheriff's report says that. And that alone is an example of an illegal eviction. It's not some friendly courtesy to take a tenant's things, put them on the sidewalk or in the driveway or on the front porch.
She will allege that your client abandoned the premises, right? I think that's what her focus is on. That's her defense on abandonment. And you think there's issues of fact there, or that she didn't meet her burden?
Our position is there is no issue of fact on abandonment, that we made the prima facie case of illegal eviction, and Margaret, in opposition, tried to raise abandonment, but she did not raise an issue of fact, in part because of this leaving the stuff outside on November 18th. But also I'd point the court to another example of illegal eviction in section 768, which is inducing the occupant to vacate. So even through some unlawful means.
So Counselor, she gives her son the notice to get out in July. And then sometime in November, she puts his stuff out on the sidewalk or curb or.
That's right.
Right. But her point in her affidavit is between July and November, he was moving out. He vacated the property. That's what she contends.
And her particular statement is, she repeats what's in the November 18th sheriff's report, which is that on that date, November 18th, he had moved out weeks ago. And so weeks before November 18th is not July 20th.
But isn't that a material question? It's a factual issue?
I don't think it is.
What he did after he got the notice?
After he got the notice, we know that he was locked out the exact day that he was given the notice. That was July 20th. He alleges in his affidavit that there was a lockout on that day, in addition to in August and a few after that. And Margaret leans on this November 18th statement that, well, he moved out a few weeks before then. And so our position is there's no issue as to whether these lockouts happen before he abandoned, if he ever abandoned at all. And I would point out additionally that his things were still in the residence this entire time. Obviously, if she put them out on the 18th of November, they were there the day before that day.
He's not looking to go back into the place. He understands he's out. He just wants monetary damages arising from the wrongful eviction, right? He's not seeking, I mean, he has no legal basis to go back in. This is month to month, and here we are many.
He wants monetary damages. I'm not sure if he would have a right to go back. I'll tell the court it's not in the record, but this premises has been sold. And so I think that ship has sailed. He's not going back.
Okay.
And I don't think the relationship with him and his mom is all that good. I'm not sure they'd be living together again.
We got that sense from the record.
If there are no other questions about illegal eviction, just briefly on the other 2 points, the promissory note and the credit card. We make several arguments on the merits of those two claims. And Margaret doesn't engage too much with them. She instead relies on this argument that the two motions were not opposed below. And that's not factually accurate. I would point the court to a case we cited in the reply brief, which is 144 Stuyvesant. I think the facts in our case are very similar to the facts in that case. That's from the second department several years ago. And I would just also emphasize that there was an opposition at oral argument. My client's attorney showed up and made arguments on each of these motions. My client submitted an affidavit that made arguments on the promissory note and the credit card. The court at oral argument seemed to assume that everything was opposed. There was no discussion in that transcript at oral argument about a default on any of the motions. Would have been very easy for Margaret's attorney to bring that up at the time, and my client perhaps could have remedied it. And that goes to our waiver point. But finally,
your client agrees that he owes the principal balance on the credit card. What is like a Sam's Club or BJ's Club or something like that?
Right.
He owes the 11,000, but he's suing for the cash back money, the $700. Is that?
So there's an issue of back.
That's the only issue is on the cash back money, that he gets a credit on that.
There's two issues on the credit card. The first is the cash back, which is, I think it's only $750, not the biggest fish in the sea here.
Yeah.
But there's also an issue as to whether statutory interest should have been applied to the, whatever that principal amount should be.
Right, okay.
Does Margaret get statutory interest given our client's affirmation in his affidavit that he couldn't make the payment? He would have liked to make the payment on time, and then statutory interest would not have run, but he was cut off from the online statement, couldn't make any payments.
Gotcha.
If the court has no further questions, I'll rest on my briefs. Thank you.
Good morning, Your Honors. Barry Donahue for Back Hills Farms. I think that sometimes it's an act of mercy to have a litigation be terminated, but it has to be done the right way. And in this case, it wasn't. At page 400 of the record, I invited opposing counsel, look, let's get depositions in this case, or let's get this case tried. Let's get these people their lives back and an ability to move on. And I detailed a little bit in that letter, the procedural history. But instead of doing either one of those things, they chose to make a motion, and there was a responding motion. Their motion was to dismiss all four of Back Hills Farms' claims. All four of those motions were granted, but the papers supplied by the movement did not support the relief sought. And so even before you get to the responding papers, the moving papers were insufficient. And I'll just briefly touch on each of those, although we did submit both a brief and a responding brief. With respect to the prescriptive easement, there's a driveway that's depicted in the record that goes from the back of the property, from the back of the house to an adjoining property where there was farming going on, both on the adjoining property and on the actual servient property. One of their contentions is that there was no farming going on for a period, and therefore there can't be a 10-year look back. The reality is,
did you need to have in order to get that 10-year look back, you needed to latch on to Dennis's license to use that driveway, correct?
so it would be
He had
Dennis.
a license to use that pursuant to the what was reported to him.
So Dennis was using the driveway since 1994. In fact, he and his father built the driveway.
He was farming, right?
He was farming back there.
But he had permission. Justice Monter's point, I think, is that he used that with permission. It wasn't adverse. Or do we have that wrong?
So the law says that in some cases where you have a family relationship, there is a presumption that it's permissive. But there's also case law that says that if you use it open and obvious and notorious, that it's presumptively adverse. In this case,
family member.
They were family members.
I could take a lot of my mom's land because I'm on there all the time.
There's no question about it, but I don't think you're running a business at your mom's house. This is what was happening here. This was a business. They were farming it since 1994. There was a period where they weren't farming, but even during that period when they weren't farming and running that business, he was bringing in stone and asphalt every 3 years. He was plowing the driveway. He was using the driveway for recreation.
Counselor, wasn't that his responsibility under the lease with his mother? He had access to all appurtenant driveways under that lease.
So the driveway
I know you say that this driveway isn't part of the lease, but the lease itself said all pertinent driveways, didn't it?
I don't remember that language, Your Honor, but the lease talks about residential use. And it's pretty clear that the lease was intended to be a residence. At the time of that lease, Back Hills Farm was farming back there, not Dennis Bauman.
Well, I think it was 14 and 15, but at the same time, a mom was giving him permission to use her leased property. You're asking for a prescriptive easement to land that he doesn't own and has no interest in. You're asking for a prescriptive easement to nowhere.
So the lease was in mom's name until she terminated.
Neither Mohawk or National Grid property.
Yeah, it was NIMO's property.
The Back Hills.
Back Hills Farm was farming the NIMO property, accessing it over mom's property. The lease was in mom's name for a while. But Back Hills Farm was paying the lease payments.
I understand that, but Margaret had the lease agreement with the utility company, and that's your second contention is that she interfered with Dennis's ability to secure his own lease.
Correct. When she terminated her lease 6 months early, he negotiated with NIMO and said, fine, we'll put it in my name and Back Hills will continue to farm.
Yeah.
So they interfered with that and.
Except you didn't plead that. Your tortious interference allegation in the complaint is that mom interfered with our farming contracts.
I agree. There's a bit of a change in the nature of the allegation, but tortious interference was clearly claimed, and that part of the claim that we've just described, they clearly were on notice of. Multiple times we advised them that there was that change. If this case had been permitted to go to trial, we could have conformed the pleadings to the proof. So there's no question there was a tortious interference claim. You're correct, though, that it changed its nature somewhat, but they were clearly on notice of that.
Anything further?
No, sir.
Thank you very much. Case 38 is Provost versus Associated Materials LLC. Case 38, both counselors are remote.
Can you hear me?
We are waiting for Mr. Gaskin, who is now here and ready to proceed. So Ms. Heisel, you may commence.
Thank you. Heidi Heisel for Appellate Dakota Prevost. May it please the court. I'll try and keep my oral argument comments briefly. This is really just a threshold matter as to who the statutorily responsible party here is in this matter. We obviously, we don't think that the court applied the facts of this case correctly, as both respondent, Creekside Renovations, and my client's employer, C&M Renovations, were both operating within the scope of work. And scope of work is one factor whether the work is in the scope of work is one factor as to whether a general contractor, whether a party is an agent of a general contractor here. So not only the court's decision relied mainly on the building permit. And our point there is that the court's decision said could or would. So what could or would have been done, whether a building permit could or would have been issued for both Creekside Renovations portion of the project and C&M Renovations portion of the product, that's not enough. And I don't think that's consistent with the case law. Here, they were both working on elements of the roof. Creekside was working on the framing aspects, and C&M was working on the actual roof, laying the rolls and laying the shingles and doing the drip edge and the like.
Who did your client work for? Your client worked for C&M?
C&M, correct.
And who hired C&M?
C&M was hired by Quadtech, who was characterized by the testimony of Hugh Foy as the sales manager. So essentially what they did is they went out to the job, met with the homeowner. They more or less bid it out. And Mr. Foy testified that he never went to the project. There's no evidence that anybody from Quad Tech went to the project at any point during the construction section of the project. In his notes, it's our position that he delegated Quad Tech, meaning Quad Tech and Hugh Foy, delegated the responsibility to coordinate the project, another element that's important for agency, to Creekside.
Well, they couldn't roof until the framing was done, correct? By Creekside.
Correct. And actually,
didn't the record show that the only communication between the two was, hey, you guys done with the framing yet so we can get to the roofing?
there was a little bit more because my client's testimony was at the date of injury, he was working on I believe it's the back right corner of the roof. So he was on like the original house right in the corner to where the rear dormer was going. And he testified.
The Creekside was already done.
They were not done. He testified.
They were gone. I mean, their truck was gone, their equipment was gone, their employees were gone, right?
They were not done. And my client testified that he was working where he was working on that date because they were still working on, Creekside was still working on the rear dormer. So they weren't supposed to touch the rear dormer. They were on the site on the date of injury. That may be where you're recalling, but he had to work where he was working and not on the rear dormer because they weren't supposed to touch the rear dormer because Creekside was still working on that. So there was some coordination. We don't have a situation here where,
Creekside wasn't supervising the plaintiff's work, right?
That is correct, but supervision is not, we withdrew our labor law 200 claim for that purpose because we don't have the burden per 200. We don't have a case for 200. And for 240 and 241 sub 6, supervision is immaterial.
So Creekside didn't hire CMN. They didn't supervise or control CNM's work. What evidence do you have that they were a general contractor rather than a prime contractor? What specifically can you point to that leads us to that conclusion here?
Sure. Well, there's number one, the building permit. They pulled the permit, which I understand is not sufficient on its own.
Okay, so we're looking for something other than that permit.
Correct. So we also have the delegation from the responsibility sheet, which is at the record at, I apologize, 920, to set the schedule between the contractors. And as I was talking about in response to Judge Montour's questions, there was some back and forth because it wasn't a clean break as one contractor stops and then the other. A lot of the cases that both parties point out, we're talking about completely separate trades. Here we're talking about trades that are within the same scope of the work. And the same scope of the work, meaning that they both had to be involved in roof decking and roof sheathing. There was testimony from Mr. Catalano, who's one of the principals for C&M Renovations, that they would replace the plywood underneath if, they were going along and found soft spots. Creekside also was within the scope of Creekside's work to do the roof decking and the roof sheathing.
Yeah, we'll take a close look. The concern is that if we say that Creekside is a general contractor subject to strict liability under labor law, then there'd be a lot of prime contractors out there all of a sudden be deemed general contractors. And there are differences there. So we want to take a really close look at that, but we appreciate your arguments today.
Thank you. Thank you for your time.
Thank you. You Gaskin?
Good afternoon, Your Honors. James Gaskin with Costello Cooning and Farron on behalf of the respondent, Creekside. This case would not be before the Appellate Division if the true general contractor, Quad Tech, had not defaulted on the case. The evidence is clear that Quad Tech was the general contractor, contracted with the homeowner, Kilbride, and then subcontracted out the job to Creekside to do the dormers and 3 windows and the porch roof, and then subcontracted out separately with C&M to do the roof on the main portion, to do the roof renovation on the main portion. So Creekside's job here was to simply do the dormer and the windows and the siding associated therewith. Quad Tech, although our client pulled the permit, our client testified, and it's in the record, that the town of Manlius will allow any one of the contractors or the homeowner to pull the permit. So it doesn't make them a general contractor simply because Creekside pulled the permit. Quad Tech paid for the permit. Quad Tech paid for the architectural drawings. Quad Tech purchased the materials. Quad Tech paid C&M for the roofing work and issued a 1099 to C&M. There's no contractual agreement between Creekside and C&M. Quad Tech paid for roofing materials and the dumpster. C&M provided its own tools, including roof jacks, walking boards, ladders. My client, Creekside, had no control or responsibility or supervisory control over this particular plaintiff or over his employer, C&M. Foy did testify that Quad Tech did walk around the grounds at times, took photos, and conferred with the customer. So they were clearly the general contractor in this case. And again, we wouldn't be here if they didn't default. I think that Judge Antonacci was absolutely correct in citing this court's case, Titus versus Kirst Construction, 4th Department, 4383rd, 1324. And in that case, Judge Antonacci said that advising that the roofing contractor, which is C&M, that the project was ready for their work does not rise to, quote, coordinating and supervising the entire construction project, unquote. So I believe that this court's already rendered a decision that's spot on, and that Judge Antonacci was absolutely correct in citing that decision. The only other case that I would cite to the court is Alberto versus DeSano Demolition Company, 19483rd, 607, 1st Department, 2021. And there the court is quoted as saying, there is no evidence that Creekside exercised, well, in that case, the defendant, exercised supervisory control over the injury-producing work. Those 2 cases, both cited by Judge Antonacci, are directly on point. And unless the court has any additional questions for me, I'll rest on our brief.
Thank you, Counselor. Case number 40 is Barker versus Gerverva. Case number 40. Longstreet, good morning to you.
Morning, Your Honor. May it please the court.
This is round 2 on this case.
I was just going to say that. You were on the first one, didn't reach the issues that are on this case. We went back down. There's another motion to dismiss on the issues that were not decided.
A lot of the same issues that were raised the first time. We didn't get to them all. You did in your brief. Has there been any discovery? This case has been pending for, we done anything below yet?
Well, not before this motion.
Yeah.
After the motion, we've done a few depositions. We're
Yeah.
waiting to, this severely limited it.
Right.
I think the main point is, and I'll just get to the point, go through the lower court's decision. This is a motion to dismiss the first 3 causes of action. The rules of a motion to dismiss are, you read the complaint, is there a sufficient allegation? On a motion to dismiss, we can submit affidavits to supplement the complaint, which we did. And then we get to and there's a statement in the judge's decision below about our claim being purportedly buttressed by a text message. I mean, that the court's supposed to look at the evidence and the allegations in the light most favorable to the claimant, not to judge it and say you're purportedly buttressing something. That to me smacks of issue determination, which you're
Or
not
summary
supposed to do.
judgment. That's more appropriate, would you say, for summary judgment, not 3211?
I'm not even sure you get there on summary judgment, but be that as it may, then we go to the next paragraph and the motion is converted to summary judgment. Under CPLR 3211, you can't convert a motion to dismiss to a motion for summary judgment unless you give the parties notice, which wasn't given. Then the court dismisses some of the claims, upholds our claim for constructive trust and unjust enrichment, but ties our hands and says, you only have a right to claim unjust enrichment or constructive trust in relation to the house, not with relation to the farm. We haven't even had discovery. I mean, there is an affidavit in the record from Charlie Folker, who was a hand on the farm, and he said that he talked to them and nothing was going to change. David had life use of the farm, not exclusive life use. They were going to build a house there. I mean, but
so there's a difference between you can stay in the house the rest of your life and you can have use of the entire farm the rest of your life. And the court's limited to the house, not the entire farm. You think that was
I think
narrow of interpretation of his claims that we have to accept as true?
Well, and I'm not even sure where we're at, because the motion, there's a paragraph that says, or a sentence that says he's converting it to summary judgment. But then the decretal paragraph says he's granting the motion to dismiss. So I'm here saying, I don't know what, but the motion to dismiss was related to limiting it to the house, and we had no further right to the farm. There are other witnesses. There's testimony, or there's an affidavit from my client that his former wife participated in these discussions. We don't have anything from her. We haven't had a chance to talk to her. We haven't had a chance to get her text messages with the other people to see what the discussions were. I just submit this was premature. It was limiting, and the lower court didn't follow the proper procedure.
Thank you.
Thank you.
This seems to be the day where all the family disputes get litigated at the Appellate Division 4th Department.
Yes, Judge, and Matthew O'Neill, Costello, Cooney, and Fearon. May it please the court. I have a concern here that counsel has made Judge McCluskey's decision much more complicated than it need be. I read the decision as not so much relating about particular tracts of area, house, farm. He made a legal distinction, which he could do at 3211, between a life estate, that very specific relief that the plaintiff sought in a portion of the complaint, and then this idea of continued use of the farm, continued use of the house, for which the court then go on that whether or not that could proceed under the equitable causes of action, that could go to summary judgment. And that is, and we have conducted discovery on that issue. Why do I focus on life use versus life estate? Because, Judge, looking at the complaint in the light most favorable to the plaintiff, giving full meaning to every allegation and expanding upon that with the affidavit submitted by the plaintiff, there's no allegation that would support either rescission or reformation of the deed. There is no claim that the plaintiff misapprehended the meaning of the deed. In fact, he goes on to clarify in his affidavit that he reviewed the deed at his attorney's office and recognized that there was no life estate, and thereafter has a conversation with the defendants in order to hash out his rights. He then signs the deed.
Right, but as you know, he's not a sophisticated guy. He allegedly had some struggling with some cognitive issues. His point was they told him your life estate's in another document because there was this contract and he trusted them. But let me just ask you this generally. There's a number of causes of actions asserted here. Let's assume the facts of Mr. Barker's allegations. He assume it's true, and I know your clients disputed all of them, but he says they come up with this proposal. We'll pay you $250,000 for a piece of property that's worth $750,000. Maybe your clients don't think it's worth $750,000, but we have to accept it is $250,000. He gets paid for his property that's worth 3 times that, and they tell him, according to him, you can live on it. You have a life estate. You can live on it. And he says, okay, struggling financially, this, that, and the other. Okay, so he takes it. And then they remove from the contract. These are his allegations. There was a page in there that talked about life estate. They take that out and he signs it unbeknownst to him. And then later's like, well, where's my life estate? He's claiming they took it out of there. The lawyer that represented him, representation defined quite liberally there, was the mother of his son-in-law, I believe. No, the lawyer who was representing Mr. Barker was related to the defendants? No?
No. The person, yes, the mother was not an attorney at all.
Right.
He provided a contract. The lawyer was an entirely independent, independent from.
Selected by whom?
I do not know
Mr.
that,
Barker.
but it was not dual representation between.
Not
plaintiff and
selected by
defendant.
Mr. Barker. That
Might-
makes that clear, that he didn't, but okay. So this lawyer who he doesn't select, that's his testimony, or that's his claim. Then he signs this contract and they pull the rug out from under him. They pull out the part of the contract that talks about the life estate. And there does seem to be some evidence there, statements from his daughter to other people that recognize the life estate. And now they say you don't have one. If all that is true, are none of these causes of action for constructive trust, unjust enrichment, none of them state a cause of action under those facts? Is there any way to recover if that actually happened?
So there's several questions there, Judge
Yeah,
Lindley. I'll take them perhaps out of
It
order.
might take a while, my apologies.
Firstly, looking at the evidence in the record, in the light most favorable to the plaintiff, there is no indication of a discussion of a life estate between the parties.
Life use?
What he could live there
For the rest of his life?
Yes, and that is what Judge McCluskey specifically allowed to go forward, understanding that a ability to live on real property is different than a life estate in which he has 100% control. Even the ability to exclude the defendants from living there.
Right.
And so the idea of that there's some further ability to possess and control or have some profit from the real property, that case is still alive. And that is proceeding both in the nature of unjust enrichment and in the nature of constructive trust. And that provides, and that is plaintiff's recourse under the current state of the pleadings. Respectfully, Judge, if we reach a point where unfulfilled oral representations are
false representations. Fraudulent.
No.
If we accept the truth of these allegations, there's fraud going on. If we
Maybe
accept the
back
truth.
up. So the allegation, which is frankly ridiculous, that the contract was somehow manipulated, which I put absolutely no stock in, but I understand that the court must under the standard.
Right.
There's no allegation that he relied at any further point upon that document, and he only discovered it after the closing. What does he rely on?
He relies on the fact that I would never sell a $750,000 property for $250,000. And that's what he says, like, unless I knew I had the right to live there.
But Judge, he signed the deed. He signed the deed.
Right.
And so that is, and the deed is dispositive as to the issue of the life estate, which is the sole issue before this court. Whether or not he has any other possessory rights over the property, that is still a live issue.
Right, okay.
Otherwise, and because the deed is, and there's no allegation that he misapprehended the deed or that there was a mistake in understanding the deed. And if you look at his affidavit.
Wouldn't there arguably be a unilateral mistake here wherein Mr. Barker believed that he had a life use? Again, what the question that Justice Lindley indicated, with, I got a $700,000 piece of property. I'm giving it to you for $250,000. Basically, I'm depriving my other children of inheritance by doing this. But I have an understanding that I have a life estate, and I'm going to do this because of that. I'm in a financial situation where I don't know if it's dire or whatever it might be, but I need some funding. And here I have a situation where my daughter and son-in-law are going to provide me with some funding here. In addition to my understanding, I'm going to get a life estate for this. Why would I do that? Tell me what benefits me in this regard when I'm giving up $500,000 in a situation here.
So your initial question, Judge Montour, was whether there was a unilateral mistake, and we know from
My
the
whole question related to that, but go ahead.
the plaintiff's own words let us know that there wasn't. If we look at his affidavit in pages 103 and 104 of the record, he makes clear that he went to the attorney's office, reviewed the deed with what he calls the secretary.
Paralegal or secretary about this. Hey, where's my life estate? It's not in here.
Exactly. He said, "Where's my life estate? It's not in here."
Right.
They told
him, signs it,
but they tell him, "Don't worry about it because it's in another document. It's enforceable." This is what he says.
Yeah,
and that's not cognizable if they lied to him.
Not for rescission of the deed. It would be with regard to the remaining causes of action. For rescission of the deed, because otherwise the statute of frauds and the merger doctrine are gutted of all meaning. If we can allege that there was a some, in this case, verbal agreement afterwards, and specifically this was addressed squarely. Well, I would say that the judge, this court's Picard decision, but also with the Second Department's 2009 decision in Gold Coast Homes versus Canucio, 6283D 748, wherein the court held that the deed controls merges with the purchase contract, and any subsequent oral representations or agreements are barred by the statute of frauds. I'm unaware of a statute of frauds exception where, well, this guy, he's kind of old, he was 57 at the time, and might not have understood what he was doing.
Doesn't mean you can't have cognitive difficulties at 57, but go ahead.
Understood. That'll be for the next motion for summary judgment, I perceive. But moreover, that's not an exception. His agreement was what he signed the deed, and this portion, the portion regard to the life estate and what title passed to him, unless he pleads the elements of rescission or reformation, which were not done, that element ends, and what remains is whether there was an unfulfilled promise, and that sounds an unjust enrichment, and Judge McCluskey expressly allowed that to go forward.
Right. So this case, no matter what we do here today, is going through discovery. There'll be summary judgment in all likelihood.
Very soon, yes.
Maybe a trial. And then we'll be back here again, and we very much look forward to that round 3.
All right. Thank you, Judge.
Thank you. Case number 41 is the estate of John Shanner Jr. Case 41. Counsel are remote. Ms. Tyverson is here for the appellants. Mr. Vocal for the respondents. Counsel, you may proceed.
Thank you, Your Honor. Actually, after reviewing the briefs and preparing for today, unless the court has any questions, I would rely on our arguments, which I think have been fairly fleshed out regarding our position, that the court lacked the ability to make the factual determination that it did on a motion to dismiss, looking into the intent of the parties inappropriately, when in fact the intent was clearly exposed in terms of the documents that were signed and the judgment that was entered, etc. We also bring an argument forward regarding the cases relied upon by the court were silent with respect to the binding nature on all parties and their respective estates, etc. But our position is simply that the court made an improper factual determination. Unless the court has any questions, I would rest on the arguments in my briefs.
Thank you. Thank you very much.
Thank you.
Vocal, do you wish to be heard above and beyond your brief?
Just briefly, Your Honor, we don't believe that the surrogate court erred by looking into the intent of the parties because intent was really irrelevant. The fact is that this is a surrogate court proceeding to enforce a non-existent judgment. There was no judgment in existence for the surrogate court to enforce, and petitioner goes to great lengths to try and manufacture reasons and explanations as to why there isn't. But the surrogate court did not have to get to intent because the fact is that there was no judgment at all to be enforced.
And if we got there, I think you're relying on the provision of the agreement that the plaintiffs in that underlying action agreed that they would proceed only against the insurance cover provided by RAL and another carrier, and that speaks for itself. They agreed they were going to go only after insurance money. They were not going to go after any personal assets of the defendants, and therefore they can't go after the estate of any defendants. And I think that's, if we get there, that would be your interpretation of the agreement.
Well, yes, Your Honor, but before you even get to that point, the fact is that surrogate court has no power to create a judgment. They can only enforce the judgment that exists.
Yeah. I think that you have an alternative argument, even if we get there beyond the judgment issue.
That is right. And I think that that's fleshed out in the briefs as well.
All right. Thank you.
Thank you, Your Honor.
Case number 42, Justice Montour is recused.
No, it's 43.
I'm sorry.
43.
43 you're recused?
Yeah.
Okay, my apologies. Case 42 is Perone versus Surftronics.
Justice Del Conte.
Justice Del Conte. I have my recusals mixed up here. Good morning.
Good morning, Your Honors. Alicia Naik on behalf of Plaintiff Appellant, and may it please the court. As I was preparing for oral argument today, I obviously had a chance to re-review the briefs, and in doing so, I thought of a point that I, of course, discussed in the briefing, but I wish I had just emphasized a little bit more. And that is that opposing counsel asserted the exact same 3 privileges for every single document on the privilege log. Now, that's, of course, the HSC report itself, its attachments, and its exhibits. They've asserted the same 3 privileges. That's in contravention of what the CPLR says to do and what the commercial division's rules say to do.
So you don't think you can have an attorney-client privilege on work product? They're mutually exclusive? Or the attorney-client privilege, an attorney's hired to do something in anticipation of litigation, and it could be privileged under more than just one privilege?
I'm not saying there's not a world in which there are certain documents to which all 3 privileges apply, but I think this was clearly a copy and paste exercise of just asserting all three privileges in response to all the documents. And the reason I say that, and I'm happy to go through the timeline, I have it prepared here, but I won't bore the court with it unless you'd like me to. In Mr. Miller's affirmation to the trial court briefing, he goes through the timeline that led us up to this point. And if you look at Exhibit X to the trial court briefing, that indicates the first example of the privilege log that we got in relation to these documents. And it's just one entry, HSE report and all related materials. It's one line, and they asserted all the privileges. And then it took months for us to get what is now the privilege log at issue, Exhibit Y, where it simply just breaks down the documents, but still just asserts those same three privileges.
We could go document by document down the log, but why don't maybe we should start with the Harder-Seacrest report itself. We have the report and then we have evidence that's cited in there, the exhibits.
Sure, let's start.
So if we start with the report, the trial judge, the most prevalent privilege is the attorney-client privilege, I think. Would you agree? That's the most cited one. So how is the trial judge wrong here? This was the corporation, this public corporation retains Harder-Seacrest to investigate allegations of wrongdoing. There had been a draft complaint from the plaintiff in this action. And there had been other allegations in the past from wrongdoing. So Harder-Seacrest does an investigation, interviews all these people, prepares a report for Servtronics. It's reviewed by that special committee. The reason they have a special committee is because two members of the board were allegedly involved in this. So the way the trial judge seemed to look at it is you have a client who's anticipating litigation. That came shortly there. I mean, the day that they were retained, Harder-Seacrest, the litigation actually came. And it investigates the allegations and other allegations. You're at a disadvantage because you don't know what the report says. The trial, and we have to be careful of what we say about this report, but assuming there's legal advice in there somewhere is what the trial judge said, how is that not privileged?
Well, let me start with the attorney-client privilege. First, that has to be a communication between client and counsel, and it is just unclear from the record who the client is in this case. At some point,
Servtronics is identified in the retainer agreement as the client. Servtronics itself, not the board of directors, not the special committee.
okay, but in paragraph 4 of the engagement letter, it says that the results of the investigation and the report will not be shared with anyone outside of the special committee, absent specific instruction by the special committee.
Right.
And we haven't seen that specific instruction. But assuming it is the client, well, I guess if Servtronics is the client, that creates a whole host of other issues. So let me just make a note to address that. The point is, if Servtronics is the client, clearly. So I guess my response to that is who then at the client at Servtronics would be entitled to this information? Would Ken Turbovich be entitled to it because he still worked at Servtronics at the time of the investigation?
Well, he was on administrative leave. I think they say, and I don't know, I mean, you allege he was provided with the report. He may have been provided with, and you say the board itself was provided with the report. You say the SEC was provided with the report. It may be a distinction between the report and the results, the conclusions, perhaps.
Okay, well, let me start with an affirmation from Harder-Seacrest. This is Mr. Feldman's affirmation, and this is in the record starting at page 752. And he indicates there, let's see exactly where. Okay, well, actually, let me go back to paragraph 4 of the engagement letter. Report to special committee. We will provide our legal advice and shall report the results of our investigation directly to the special committee rather than to the board of Servtronics, Inc. or management. We will not share our advice or the results of our investigation with management or the remainder of the board of Servtronics absent specific instruction. And if we go to the public filings, it's clear that at least Some of that substance, the results of the investigation were shared with the board such that they had enough for the board to provide Mr. Turbovich with a notice of grounds for proposed determination that listed certain grounds identified during the investigation. So at least that portion of the report, that would be a waiver, Your Honor. The portion of the report that lists the certain grounds identified during the investigation for Mr. Turbovich's notice of grounds for proposed termination. That was shared with Mr. Turbovich. That was clearly shared with the board.
Is there a difference between the conclusions or results of the report and the actual content of the report? That's what your opponent tries to draw a distinction there. And maybe you're right that once you open the door and you say, this is what our conclusions are, that's waiver. You've disclosed it.
And to your point, Your Honor, it's a little difficult for me to assess that, not having seen the documents. Is there a difference between the investigation itself and the results of it? Well, I guess I haven't seen any of it, so why didn't I get a redacted version, I guess? So if there are portions of it that are just results or things that Your Honors feel aren't privileged, then I should have almost a year ago at this point received a redacted version. And the trial court, after having reviewed it, should have ordered a redacted version. And that's the point that I try to make here, that if all of these privileges are going to be asserted with respect to the entire report and all of its attachments, there needs to be a more nuanced analysis of what exactly is privileged and what I'm entitled to, at least in redacted form.
I understand.
But I would argue that there was a waiver if the board took that information and then acted on it, because that would be acted on in a business capacity. So in the 8K, I've cited several excerpts, but one is that the board of directors scheduled a meeting to consider and act on the grounds for Mr. Turbovich's proposed termination. So at that point, the board of directors at least knew enough about the investigation to be able to say, hey, we need to hold a meeting. We need to consider what these proposed grounds for termination are. And they also had enough to say that he violated, Mr. Turbovich, his employment agreement, and that he committed willful malfeasance. And that language from the AK said the board determined based on the findings of its investigation. So to answer your question, I mean, I would think a finding of an investigation is different from a bottom line conclusion or a result. But again, I haven't seen the documents.
But your argument is premised on the fact that either Hyder Seacrest or the special committee, which was really a subset of the board of directors, they waived the privilege by sharing the report with the full board and with Mr. Turbovich's lawyer, I guess, and with the federal government. With respect to the board of directors, if Servtronics is the client of Hyder Seacrest, then why would there be a waiver if the board of directors of Servtronics gets the report? They're part of Servtronics. They're not outside parties.
Well, then what was the point of respectfully having a special committee? If Servtronics is the client, if that entails the board.
Right. Well, it's clear from the record, the reason for the special committee is that two of the targets were on the board of directors and they wanted people to speak freely. And they, when the hair seekers going around, Mr. Feldman and his associates going around to all these people, and they're promising confidentiality. And I think that was the Mr. Cosgrove affidavit, I think, explains that, and it seems kind of obvious. That's why they had the special committee.
But then if Mr. Turbovich and the other member of the board who was being investigated were not on the special committee, but then the report was shared with the board, which Mr. Turbovich was on, and the person, other board member who's being investigated was on, I mean, that does to me, Mr. Turbovich is an adverse party at that point, and that does seem like a waiver to me.
I think they say, and I'm not saying it's true or not, they say in affidavits from Mr. Feldman and Mr. Cosgrove that it was not shared with Turbovich. He wasn't giving any upjohn warnings, or he was treated differently. And so to believe them, Turbovich and his lawyer did not get it.
Okay.
I don't know, maybe we don't have to accept that at face value, but that's what they say.
Okay, well, let's assume that that's true. I guess I have a couple of responses to that. It's unclear from the privilege log, and this is in part because, as I started saying, the privilege log isn't as specific as it should be, but it's unclear, for example, if the notice of grounds for termination is an exhibit on the privilege log. Now, that's something that's undisputed was shared with Mr. Turbovich, and we have not seen that. So that's a perfect example of just throwing the kitchen sink, all three privileges, that everything on the log were clearly entitled to at least some of it. That's a perfect example. That was a document that was, according to the 8K, provided to Mr. Turbovich by the board of directors. To say that he still was employed there and the attorney-client privilege applies, again, then what is Servotronics's, I mean, they're incentivized to not fire him until after the investigation, just so that they can keep arguing privilege.
What number document is that one you're referring to?
Excuse me?
What number document is that the one?
Well, it's on the privilege log. It's difficult for me to assess because it's unclear what some of the documents are. There is a document on the privilege log that's just described as quote, exhibit to the HSE report. So I mean, you have the documents in front of you. I don't. The best I can do is say that perhaps that is what the notice of grounds for termination is. We have asked for it. We haven't gotten it. This is, to my knowledge, the only privilege log that's on the record. And so it has to be somewhere on there. But that's an example of something that, you know, we should have received. And to assert.
Go ahead. Fair enough.
Okay, and to assert that this would still be attorney-client privilege because Mr. Turbovich still worked at the company, again, it would just incentivize you to not ever fire an employee you're investigating so that you can continue to claim privilege while he still works there. He was clearly in an adverse position. The privilege log made clear he had his own counsel. Mr. Boreanaz, if you look at the privilege log, there are several references to him, one in September of 2021, one in October of 2021, before this report was finished and given to the special committee. So at that point, if Servotronics is still representing Mr. Turbovich, I'm not sure why he hired his own counsel. And to that, I would also point you to Mr. Donlan's affidavit in the record. He talks about why the board minutes should be privileged, essentially. He's laying the foundation for that. But nowhere in Mr. Donlan's affidavit does he say that he represented Mr. Turbovich. And so to the extent that there are emails on the privilege log, which there are, and I'm happy to give you a citation to that, an email between Mr. Turbovich and Mr. Donlan, the other side's asserting attorney-client privilege over that. Mr. Donlan in no way represented Mr. Turbovich, especially when Mr. Turbovich was being investigated. That's control number 007-20665. And it contains a copy of the email at control 005-49369. This is referred to in Feldman's affidavit, page 757 of the record, subparagraph C. And I'd like to point to defendant respondent's brief on page 36, where they argue Turbovich was an employee of Servotronics communicating with its attorneys for the purpose of providing legal advice. And just nowhere in the record would it indicate that Mr. Turbovich would consult Servotronics' attorney for the purpose of providing legal advice in a case where he was being investigated. And so you can see the theme here is just an over-assertion of privileges, all three of them in response to 90+ documents on the log.
Right. I read your brief, the main argument that I got out of it. There's a lot of arguments, a very complex case, and we'll go through every exhibit item by item to see
I appreciate that.
if any one of the three privileges applies. Trust me, we will do that. But the main point I got with respect to the Harder Seacoast report was that the attorney-client privilege doesn't apply because its predominant purpose, its primary purpose was not to render legal advice. It was to help the business, to help Servotronics make business decisions. That's your A1 argument, because if you're right on that, then the whole report needs to be turned over. On that issue, I think the stand's a little different than in anticipation of litigation, right? Is that it doesn't have to be the sole purpose for the attorney-client privilege, just the primary one. Your argument relies a lot on the fact of the engagement letter. So purpose of this retainer is engagement is to investigate the draft complaint, which then turned into a real complaint. And then the other purpose was to investigate other retaliatory complaints in the past, going back to 2015. So, and you're focusing on the second part of that, right?
What do you mean by the second part?
The second part of the engagement letter, it says we're going to.
Oh, as well as allegations of retaliation by others.
There's all these other allegations, and you go through all of them. I mean, this was not the first time, okay, allegedly. And so, and that is more a business purpose in your mind, that there's no legal cases from those other complaints, right? The only draft complaint was with respect to Mr. Perone.
Well, I'm not conceding that this report only investigated allegations that are listed in our complaint. No. And that's for a couple of reasons. So first, again, I would go back to the Feldman affidavit. So Feldman worked at Harder, Seacrest, and Emory. On page 760 of the record, he says, our investigation also extended to a review of other contemporaneous allegations related to Ken Turbovich not made by Mr. Perone. He doesn't
Correct.
say old allegations. He says contemporaneous
Exactly,
allegations.
yeah, unrelated. And
Unrelated to
you
Mr.
put them
Perone.
in your brief, there's a lot of things that in the past, but wouldn't Harder Seacrest in defending Perone's action, the issue of notice and so forth, doesn't prior allegations of misconduct of a similar nature, because there's a lot of allegations of sexual misconduct and wasteful use of corporate funds and so forth, wouldn't those be relevant to the notice of issue, notice here, relevant to the issue of notice in the Perone lawsuit? We need to investigate prior instances that's relevant to this current lawsuit. Would that not be the case?
But I don't think it's clear from the record that everything that was investigated by Harder Seacrest, including old allegations, were simply the ones listed in the brief. And let me point you to a few reasons in the record why. So one is at oral argument before the trial court, Mr. Doyle, who is arguing for defendants, referenced other investigations. Just give me one moment to find that page. Okay, so this is at page 843 of the record. And this is the oral argument before the trial court. And this is when we're talking about whether they've waived all privileges because of the affirmative defense they've asserted, which I'll also get to. But Mr. Doyle says our defense is going to be our investigation at that time of whatever allegations were brought to us was adequate under the law, but we will not be citing the HSE investigation in support of any affirmative defense that we raise. So that indicates that there are other investigations that took place at the time of whatever these old allegations were, whether they were in Perone's complaint or not. So if there are separate older investigations, then that actually means the Harder Seacrest investigation investigated not the old allegation, it investigated whatever Den's complaints and I don't know what allegations of retaliation by others means. And frankly, it's not my burden because it's not my burden to prove these privileges. I'm just doing the best I can, a little bit shadow boxing against documents I haven't seen.
Right.
But to the extent that other, I guess, allegations were investigated, I would argue that has nothing to do with litigation. That has to do with the company's responsibility to investigate those under the employee handbook, as I've laid out. But also there were clearly these other investigations at the time. So why would Harder Seacrest have to reinvestigate those?
Yeah, I mean, I think the argument, you make a lot of good points and you're very good here, but I think the argument would be in defending the Perone lawsuit, if they had notice of other misconduct, a pattern here, and they didn't do anything, that would be relevant to the Perone defense.
But if they didn't do anything, Your Honor, and they asserted the affirmative defense that they did, then all of these privilege arguments go out the window and we're entitled to it because they've put that investigation at issue. You can't assert an affirmative defense and say, we did a great job looking into this. And the exact words, the answering defendants exercised reasonable care to prevent and promptly correct unlawful sexual harassment and similar behavior, if any, and the plaintiff unreasonably failed to seek preventative and or corrective opportunities. You can't assert that as an affirmative defense and then hide from me the discovery that you would rely on in support of that defense. And then on one hand, you're saying, well, you're not going to rely on it. So actually, you're not entitled to it. And under no rules, any case law, would the standard for discovery be what you're relying on? I'm not entitled to just what you're relying on. I'm entitled to what's responsive. And you've waived any privilege by asserting that affirmative defense. You shouldn't have raised it. And to say, well, we're just going to rely on these old investigations, whatever investigations happened at the time of the allegations Well, then on the other hand, you're arguing this investigation took place at the time of these allegations. So why am I entitled to the old investigations in theory? I still haven't seen any of that. But let's say I have, or let's say it has been produced. Why am I entitled to the old investigations based on whatever allegations at the time were brought to the company's attention, but I'm now not entitled to this investigation? And how on earth am I supposed to vet this affirmative defense if I don't see what the company did in response to these allegations, if they're relying on that affirmative defense?
Anything further?
No, Your Honor.
Thank you very much.
Good afternoon, Your Honors. Andrew Devins, Connors LLP for Servotronics Incorporated, its board of directors, and its subsidiary, the Ontario Knife Company. May it please the court. Good legal advice requires that we keep our clients' secrets. That's especially true when those clients are facing actual litigation. Like here, where Servotronics received a draft complaint in this very lawsuit and hired outside counsel, Harder Seacrest and Emery, to conduct an internal investigation of the complaint's merit. Now, the plaintiff is asking to compel that law firm's report and communications about the investigation. But those documents are privileged. Judge Kaye's Court of Appeals said so 30 years ago in the seminal Spectrum and Rossi cases. And the motion court correctly recognized this, conducting his in-camera review. The standard review for this court is abuse of discretion, and there's no evidence that Justice Koliakovo abused his discretion. Now, the CPLR has three categories of privilege, and my colleague said that we assert the exact same privileges for every single one of the documents on our privilege log. That's not improper if they all apply, and they do here. But as you noted, Justice Lindley, our primary argument is that the report and communications about it, documents on the privilege log, are privileged because they're attorney-client communications.
And that turns on whether the primary purpose was to provide legal advice from Harder Seacrest to Servotronics, rather than just general advice to make solid business decisions. Is that really what the dispositive issue there is?
That is certainly the most important issue. And it's not whether, and I want to emphasize that the inquiry is whether the predominant purpose of the communication does not need to be the exclusive purpose. It's okay if there's some business benefit after the fact, like employment actions mixed in, but here we can't ignore the proximity to actual litigation.
Wouldn't the distinction between legal advice, getting legal advice and getting business advice, it's almost impossible to separate when you're talking about a lawsuit, especially the settlement of it. A settlement and a lawsuit is always going to be a business decision, would it not?
Well, that may be true, but the fact of the matter is that whenever there's a communication about litigation, it's presumptively a legal communication. I mean, it has a legal purpose. I mean, that's what we do as attorneys. And the Court of Appeals and Spectrum and Rossi both found that it was presumptively a legal communication there. And
this is my point, I guess, is that if you retain a law firm to represent you in proposed litigation or actual litigation, there's necessarily going to be some business decisions made as a result of that advice for the company.
Yes, and that's
why
why
separate that out.
Exactly.
Impossible.
And we don't, and that's not the standard, that's not the law. We don't make those surgical separations because that would pose an inordinate risk of revealing the client's confidences to try to make those kinds of separations. And of course, a complete lawyer, complete legal advice has to lead to these other sorts of decisions. So I also want to address the confidentiality of the report. It's established in the record from the affidavits that we submitted that this report from Harder Seacrest and all the documents in the privilege log were provided only to the special committee and no one else, as you noted, Justice Lindley. The argument from my colleague is that in the 8K disclosures, it says that the board made a determination. But that does not mean that any of these documents were shared outside of the special committee. It proves too much. For example, Justice Del Conte is not participating in oral argument, but Your Honor's decision in this appeal will just as much be a decision of this court and this panel. The special committee acts for the board, as you noted, Justice Lindley, there's a special committee of 3 because the other 2 of the 5-member board are conflicted. That's the whole purpose of the special committee, as I think you addressed, Your Honor. And also to the point of the relationship between attorney and client, it's a relationship between counsel and Servotronics that is established by the engagement letter. And also we have submitted the affidavits of client and counsel to that effect. Reference to the legal advice, to receiving legal advice or consulting an attorney, such as my colleague argues happened in the 8K, did not disclose the substance of what that legal advice was. But again, that proves too much, nor does it change the purpose to refer, nor does it change the ab initio purpose of the communication to refer to it later in an 8K disclosure. And it also, might have seemed, like, for example, to the motion court, that there was perhaps more of a business purpose than there really was. I want to note for Your Honors that the complaint originally alleged causes of action for waste and other derivative claims. So in order to investigate this complaint, Seacrest had to get into things that had to do with how the company was being run and make some evaluations about that. But again, still a predominantly legal purpose because it's all in response to litigation. And Justice Lindley, you were on the panel, and 3 of the cases cited in our papers, Color Dynamics, Nicastro, Microlink versus Town of Amherst, all of which, when there was a prospect of litigation, it was a protected privileged communication. But they're not just attorney-client communications. That's why we also noted them as attorney work product and materials prepared in anticipation of litigation. It was not a copy-paste job. If you look at the privilege log, the things on there are, other than explicitly emails or communications, you've got reports, exhibits to the report, a memoranda from attorneys, attorney drafted documents, attorney interviews of witnesses. All of that is the product of a lawyer's professional skill and certainly contains attorney's mental impressions. And as the trial court noted, that's all attorney work product and would be privileged from disclosure for that reason alone.
Wasn't there a Miss Miller here involved?
That's correct. Yes, she was one of the witnesses that counsel interviewed in order to provide the legal advice.
Well, I don't think she was interviewed. I think she just gave an affidavit, right?
That there was contact between
right. She didn't want to be interviewed.
I believe that's right. Yes.
And she just said, "Here's my affidavit," but they did have her cell phone, her text messages.
Yes.
What about messages that are from her? Text messages from her involving?
So anything.
She's obviously doesn't work for the company.
Sure. Yeah. Yes, Justice Monter. So most of what's on the privilege log are communications between the employees of the company and counsel, which would be very clearly privileged under Upjohn, but communications with third parties who are not employees of the company are also privileged because they're here. They exist only as exhibits to the report. If there were some separate demand, but here it's just for exhibits to the report. That's the factual basis for the legal advice that Seacrest provided to its client.
What about text messages or emails between Ms. Miller and Mr. Turbevich? How are those tactic?
I believe what you're referring to, Justice Montour, is again an exhibit to the report. And so that factual, otherwise non-privileged information, when it's communicated from an attorney to client,
you just attach it and now it becomes protected.
Well, if I may, Justice Montour, it's not simply just attached. If you look at
it, was an attachment to it.
It was. It's an exhibit to the report.
Right.
That's the basis for Seacrest's legal advice.
Now I protect that by attaching it.
When it is the basis for the legal advice that counsel is providing to the client, yes.
The relationship between Mr. Turbevich and Ms. Miller was somewhat personal.
I believe those are the allegations. Yes. Yes.
But you just said communication between a client and the lawyer. Seacrest didn't represent Ms. Miller.
That's right, Justice Lindley. But I believe that what Justice Montour is referring to for the privilege log was an exhibit to
no, I understand
the report.
It, yeah. So yes. I mean, I don't know. We're going to take a look at each and every exhibit. I don't understand readily at this very moment how that is privileged. It's non-client, but we'll take a look at that.
So if I may, Justice Lindley, it's very clearly laid out in the Spectrum case that we rely on in our papers, that when there's factual investigation by counsel that ends up supporting the provision of legal advice,
Facts are not privileged.
Exactly, but when they're the exhibits to the report that are the facts, which are the basis, and your honors have the reports referred to in there, when that's the basis for legal advice, we don't make those surgical separations because it risks betraying the client's confidences. So whatever the lawyer is referring to, and whatever the lawyer has gathered, and it also, frankly, it's work product from the investigation. Interviews of witnesses, those are squarely within the protection of attorney work product. That's Hickman versus Taylor. And so when a lawyer conducts the interview of a witness, that is infected with the lawyer's mental impressions.
It wasn't an interview.
Yes, communications with her.
Okay, but you said interview. I don't know. I think she just provided an affidavit, but anyway, we're going to take a look at each and every one. It's going to take a long time, and we're just not going to do a blanket. This is not privileged or this is privileged. We're going to go exhibit by exhibit. First, we got to decide if the report's privileged. Any of the three apply, and then we go to the exhibit. We go through all three privileges.
I think that's correct. I think that's correct.
Yeah. So, I mean, we got so many, I don't know, I forget how many, but over 100 here, 191 or something.
It's 91. Justice Koliakovo took a look at each one of them. He said so in his decision. And I know there are a lot of documents here. They're discussed, I think, very well in the papers. No doubt it's a complicated factual situation.
But it's not all or nothing, you would agree. Some could be privileged, some could not be privileged.
Well, I think there were over 600 pages of documents that we did produce. I mean, this is a small minority. So I mean, I do think it is all here because
you think they all, but theoretically, it could be some and not all. Theoretically.
Theoretically, yes. I mean, each document that's withheld stands alone, although the report and its exhibits are unified because they're all really one attorney-client communication. So I guess the standard of review, however, is abuse of discretion. So going through that document by document analysis, I don't believe that there's really any basis on this record that Justice Koliakovo abused his discretion. I mean, there's a reason that abuse of discretion is the standard of review for discovery motions. He dove in and wrote a well-reasoned decision. It may seem complicated, but the appeal is relatively simple. This court should affirm for the reasons stated below.
Thank you. Justice Montour is recused on case 43, Rimar versus Country Club of Buffalo. We'll wait for Justice Del Conte to return. The respondent has submitted, but Mr. Little is here for the appellant. Thank you for your patience. It's been a long morning.
Had a family dispute before the court for you, Judge. Good afternoon. May it please the court, Brendan Little, Lippis Matthias, Buffalo, on behalf of defendant respondent Country Club of Buffalo. This is an appeal of a motion to dismiss. I want to emphasize 3 points. First, I want to emphasize this case is difference from this court's case in FICA midwifery, which I believe Justice Lindley, you were on the panel for that case. That complaint had specific quotes, identified employees by name, indicated that they posted it on a public Facebook page showing that they were affiliated with Independent Health. Thus, this court reversed the trial court there and said that those are sufficient allegations to sustain a motion to dismiss or to avoid a motion to dismiss. It's well settled and it's undisputed by the parties that pursuant to 3016 of the CPLR, that time, place, and manner and to whom the statements were made must be articulated in the complaint with specificity. Here we have general allegations over a potential 2-month time period that supposedly an employee or maybe the Board of Governors republished these 2 letters that were circulated to the Country Club of Buffalo. We don't know who the individuals are that supposedly published this information or to whom actually received this information.
Shouldn't we look at the letter separately? The first one was sent to Mr. Rimar himself. That one is tougher for the plaintiff. I mean, that was somebody wrote it to him. The second one was written to the board, maybe from another board member. You have a stronger argument on the first one, right? I mean, It's just a letter from one person to another. He's not defaming him to the public or anybody else.
I would agree that it is a much easier call on the first one, and that, yes, the allegations are that the letter was sent to me and the Country Club of Buffalo didn't even know about it until he presented it to the Country Club of Buffalo. So any kind of publication of the public at large.
Counselor, but just to be clear here, that's not what the allegation is in the complaint on the first cause of action. The allegation in the complaint is that it was published between March and April to members of the country club.
He
So
originally
we have to take that as true.
Right. Originally, he said the letter was sent to me. Remar is saying the letter was sent to me.
But he alleges, and
He then provided it to the Country Club of Buffalo during his hearing. And then he is then saying, yes, after the fact, supposedly some unidentified person republished or recirculated this first letter to unidentified third parties.
this feels a lot like factual questions.
It can't, Judge, because this court's Wagner, WEGNER, which was decided before FICA, says you can't cure procedural deficiencies through discovery, pre-action, or through the case. You have to come into the front door to identify who these people are. Defamation is, look, someone said something about me that is untrue to a third party and I've suffered damage. Who's the third party? How do we know? If we don't know who the third party is who received this information, how can you say the claim?
I guess where I'm struggling with this, if we buy your argument, then it's safe to defame someone as long as you keep your identity secret. That you could never bring a cause of action within the 1-year statute of limitations if the person defaming another takes enough effort to keep their identity secret. Because in this particular case, the plaintiff brought the pre-action request for discovery, then he ends up bringing the lawsuit. And the court says, you can find out, you can take some steps. You may never find out who sent this letter, but through discovery, you'll have that opportunity. You seem to indicate that if you don't plead the author of this anonymous letter, you fail as a matter of pleading.
That's your argument.
That's your argument.
The Wagner case, and I apologize if I'm mispronouncing that, indicates that you cannot cure a procedural deficiency through pre-action disclosure or discovery.
But that assumes that the pleading stage requires that you identify the author of this anonymous letter.
And this is, I got to take exception to that because this is not about who authored the letter. This is about republication and who circulated the letter, right? The claim is that the Country Club of Buffalo took these letters that they received, both letter 1 and letter 2, and republished them to someone. We don't know who. So yeah, I guess he could try to figure out who actually authored the letter, but there's no claim specifically that I don't know how the Country Club of Buffalo could author the letter of itself, because it's a 501c5, I believe. But there really isn't about who authored the letter as much as who republished the letter or sent the letters and sent them out a second time.
Not the second letter. The second letter identifies himself or herself as a member of the board.
The letter itself does say, I am a member of a board.
I'm a member of the board.
We have to take that as true.
And I've known you for a long time.
We have to take that as true. But going to my second point of what I want to emphasize is that board of governors or board of directors are not employees. That point is conceded and not opposed in our brief. And so, there's no allegation that an employee of the Country Club of Buffalo recirculated this and identifying who that employee was. And that's the big difference between here and FICA.
I don't mean to interrupt you here, Counsel, but I will. I'm not sure the plaintiff says they're employees. Plaintiff says that the Country Club is vicariously liable for the acts of its board. That vicarious liability is the issue here. I granted they're not employees. And that's a different, it seems like you're conflating those two issues.
I don't know if he necessarily I think he suggests vicarious doesn't expressly plead vicarious, but the board of governors, because the board of governors are not employees of the Country Club cannot be vicariously liable for the board of governors' conduct. So taking the allegations as true, as we must, even if the board of governors took that second letter and passed it out to these unidentified third parties who we don't know who they are, that is not sufficient basis to hold them vicariously liable because the board of governors are not employees and they can't bind the Country Club of Buffalo.
Do we know how many people are on this board of directors?
I believe there are it's an odd number, 11 or 13. I don't know the answer off the top of my head, Judge.
So according to the plaintiff, it's one of these members based on the second letter indicates somebody who's on the board. And he wants some discovery to find out who it was.
Correct. And what was somewhat in the record, and I don't want to stray, but there was affidavit signed by everyone in the pre-action disclosure saying it wasn't me. I didn't do it. So yeah, that again, I think I know it's a threshold issue, but he can't cure the deficiencies. The biggest thing is you have to articulate to who these third parties were that received the defamatory information.
I mean, you would acknowledge that it's fairly slanderous to say somebody raped somebody if it's false, but it's an egregious problem here.
It is an egregious allegation. I certainly understand. I think probably one of the worst allegations to call someone a child molester.
And you can understand Mr. Rinmar's consternation if that's false, but that's not why we're here. You're saying he doesn't know who it is, and even if it's somebody on the board, they don't work. That we're not, the club itself is not vicariously liable. So those are legal issues we're going to have to wrestle with.
Yeah, and again, my point is to whom there can't be damages, right? If no third party ever received that, how can you claim, oh, you told my employer, you told my neighbor? If there's no allegation that this person received that information, how will you be able to articulate your damages? And that's why the standard of specificity is to whom the statement is made, and it must be pled. And so my final point, I want to emphasize the third and fourth cause of action we believe are barred by the 4-month statute of limitations under Article 78. The central position in each of those allegations is that the Country Club of Buffalo failed to follow its own constitution and rules and improperly terminated his relationship. That's purely the Bango case in the third department. That's an Article 78 review. You can call it breach of contract. You can say I want money damages, but the Bango case from the third department disposes of that argument. And so we believe the third, fourth, and fifth causes of action are barred by the 4-month statute of limitations, and those should be dismissed. For those reasons, we ask the court reverse and dismiss the case with prejudice. Thank you.
Thank you, Mr. Lee. Last case on, and we'll wait for Justice Montour to return, but the last case is Hazlitt versus Niezgoda, argued remotely, case number 44. All right, we are ready to proceed. Mr. Monaco, you're the appellant.
Oh, thank you, Your Honor. Richard Monaco, if it please the court, for the appellant. And I'm going to be as brief as possible. It wouldn't be a complete day in the appellate division without an auto negligence case. So fortunately, we're giving you one, Your Honor. I'm going to primarily rely on my brief. It's been a long day, but I just want to make a couple of important points. I'm sure the court has seen them. There are actually two distinct claims in negligence. Obviously, the more interesting claim is the diminution in value claim. And I'll get to that in a moment. Again, I'll be brief. But the loss of the right to use claim is a separate claim. Now, we have competing summary judgment motions. The appellant moved for summary judgment. I'm sorry, liability was stipulated. So we're only talking about damages here in this auto accident case. Second department case law, fourth department case law, all the case law concludes during a reasonable period to repair the vehicle, you get a per diem for the loss of the right to use the vehicle. I don't know how or why the case was dismissed on summary judgment for that reason. I can only assume that the court below did not take well to my expert testimony, but as this court is aware, there was no countering expert testimony put forth by the respondent. I would submit that summary judgment should have been granted in favor of the appellant, at least on the loss of the right to use claim. We're the only ones who are an expert.
Could we narrow this down a little bit on your loss of use first?
Yes.
You're relying on Jacobs and Judge Doran's decision.
Yes.
In Doran's decision, it was a BMW that was damaged, and he gets a Toyota Camry, I think, some type of Toyota, which was not comparable. So there was $7,200 loss of use claim that was recognized there. We had the case on an appeal, but not that issue. The defendant didn't cross appeal, so we didn't pass judgment on a loss of use. Here we have a Tesla, $68,000 roughly Tesla, and your client's given a Nissan. Your argument is those are not comparable. He's not made whole. He's lost 33 days of use of his luxury automobile. He's given a Nissan, which in his view is not comparable. So this is Jacobson, right?
That's correct, Your Honor.
Now, with respect to your burden of proof, maybe I missed it, but there's a lot of different models of Nissan. I couldn't tell in the record what type of Nissan. Some of them, you look online, they're more expensive than Teslas. There's some that are worth 150,000. There are some that are worth 20,000. Don't we need to know, assuming that we agree with you that there's a loss of use claim here for non-comparable vehicles, how can we know if his Nissan was comparable? We don't even know what kind it was.
Well, we don't make it up as we go along, especially in front of appellate panels. I'm not sure, Your Honor. I'm not sure. And I would suggest that the court should say, okay, well, there's an issue of fact here. Let's set it down for an assessment on that valuation, taking into account the vehicle that, that was offered. Let's take a look at this. But to wholesale dismiss the cause of action, to non-suit the cause of action, doesn't seem to be in compliance with any of the appellate law.
Right. I think on your motion, because we have cross motions, you have the initial burden of establishing as a matter of law, the vehicle he got was not comparable. And I guess the argument could be made, well, you didn't meet that burden because you never even told us what kind of vehicle it is, but that doesn't resolve, your case was dismissed. So the defendant now on his motion has the initial burden of showing, if we accept this comparable use doctrine that Judge Doran recognized, they have the burden of showing that the vehicles were comparable and they didn't meet that burden either, in your view, right? So it should go, there should be a trial on this issue.
That is exactly what we'd be arguing on that one of the two issues, Judge. Correct. Correct.
You, on the loss of value claim, your client is arguing within the context of our decision in Freitas versus in the Freitas case and all the other cases that your point is this car was not fully restored to its pre-accident condition. And the reason it wasn't is his allegation under oath during his deposition that there were gaps in the paneling that were unsightly. Car ran fine, no problems with its operation, but the paneling wasn't correct. The gaps were too big. And so it was not restored to its pre-accident condition. That's the allegation, right?
That's all exactly correct, Your Honor. There were a couple of items as well regarding the paint and problems with a trunk seal that persisted, but the way Your Honor has encapsulated the argument is exactly correct.
So doesn't your client have to, for diminution in value, for his summary judgment motion, have to establish as a matter of law that there's a diminution in value as a result of those gaps? Not just some aesthetic difference, but there's the proof he has, whether it's admissible or not, his expert says there is a decrease in value, but that was tied solely to the resale, which we all know if you get into an accident, you're not going to be able to sell your car for as much. His report was focused only on that. You didn't seem to have any expert affidavit or anybody saying because of these two wide gaps, the value of the car has gone down. So is that a problem on your motion?
It is not as specific as I would like it to be, as Your Honor has just outlined. And again, the cause of action should not have been dismissed. It should have been set down for inquest as well. But yes, I mean, would it have been better? Yes.
Counselor, if I may, as I read the deposition testimony, your client says in sum and substance that my car was fixed and it worked, but it wasn't fixed right. The colors don't quite match up and I got these gaps, and then for a while I had some leakage around the seals. So my car wasn't restored. I'm not necessarily referring to the fact that I've got some additional depreciation, market value loss because of the accident, but I didn't get the benefit of a full restoration.
That is exactly correct, Your Honor. And I must argue that, or I can't get diminution in value. Yes, I must argue that the car was repaired, but was not restored to its pre-accident condition. Okay, not value, pre-accident condition. I must argue that.
So given that, following justice, what evidence in the record is there of what work needs to be done or the value of the restoration work that hasn't been completed?
It goes back, I think, to Justice Lindley's decision. I'm sorry, questioning before. I think it may be very similar to what Justice Lindley was saying. I think the expert report could have been more specific in that particular regard. For instance, the panels, the paint, the trunk seal. Yes, I do agree on that. He's giving a statement that the as to the current value of the car as repaired. These perhaps would be good grounds to deny my motion for summary judgment, not to non-suit the appellant. That would be our argument, Judge.
Can I just clarify, maybe I misunderstood the record. There were problems with the seal of the trunk and colors. Your client took it back and he complained. There was some adjustment made, but eventually he's left with his main complaint is the gaps are too wide on the paneling. And they said, there's nothing more we can do on that. And he says the gaps are wider than they are on a new Tesla. Are we just talking about gaps now, or are we talking about leakage into the trunk and all that other stuff?
I think he was talking about the paint still didn't match up, and he had it. I don't think we're talking about leakage, Your Honor. I think he's saying there was some problem with the trunk seal, and that wasn't resolved. But again, I don't want to mistake the record. I believe that's where we were. Again, if the car is restored to the pre-accident condition, there's no diminution in value case under any department that I can see.
Would you agree, last question for me at least, if you get your foot in the door on this diminution in value as a result of the gaps, the proof at the damages trial is limited to the decrease in value of the gaps. We don't get into your expert's opinion about the decrease in resale value as a result of the car being involved in an accident. Would you agree with that?
I would need a change in Fourth Department law to get that. I have requested that, whether I get it or not.
Right.
Yeah, let's just say I got one of the football games right. I picked Houston. I lost it on all the others.
Okay. Thank you very much. Yeah.
Are there any other questions from any of the justices of the panel? All right. I thank Your Honors for hearing me and for hearing me virtually. You'll see my office is in Manhattan, so thank you.
Right. Thank you. Mr. Cosgriff.
Afternoon, Your Honors. James Cosgriff on behalf of defendant respondent. And I think our brief is pretty clear. I mean, there's absolutely no question this car was repaired to pre-accident condition. Plaintiff testified unequivocally at deposition that this car was repaired to his satisfaction.
Hey, can we just stop there? Because I looked at that. I saw that in your brief, and I'm curious where you get that out of the deposition. I know that plaintiff testified that it rode fine. There was no problems with performance, but page after page, he's complaining about the gaps. Now, maybe that's unreasonable. Like, I could care less of the gaps in my car, honestly. It makes no difference to me. Probably to most jurors if they ever get this case, but it evidently bothered this plaintiff. And he's saying the gaps are too wide, so it's not in the same condition it was before the accident, where the gaps were narrower.
Well, he was specifically asked the question at deposition about whether or not that was repaired to his satisfaction. He answered in the affirmative.
What page is that?
The gaps,
what page? Can you cite me to the page? Because I've looked very closely for that one. Do you know? I think you cite 102 in your brief. I don't have it in front of me, but is that where you're looking at that? Yeah, I know. I'm putting that in your spot.
That brief open in front of me either, Judge, but if that's the number I cite, then that'll be there.
Okay.
But in terms of the gaps, as far as we're concerned, this was all created after the fact. He did admit that he took the car back, adjustments were made. He's got nothing other than a mere claim that was still an issue. We have nothing beyond that. That in of itself does not support his case here, or should be any reason to deny our motion.
Counsel, let me frame this in terms of your cross motion. Your cross motion is that are no damages here as a matter of law, I suppose because the car was restored to its pre-accident condition, that would be your burden, right? To establish unequivocally that the car was restored to its pre-accident condition.
Yes.
And if the plaintiff testifies, the colors don't quite match up. Aesthetically, it looks crummy because of these gaps that are there that weren't there before. Wouldn't that be a question of fact as to whether or not the car was restored to its pre-accident condition?
Well, based upon the papers, Judge, no. There's nothing from the plaintiff other than a mere claim.
Yeah. Well, I guess is where I want to focus my question, because I'm asking you, in your moving papers, where do you establish, how do you meet your burden to show that this car was fully restored to its pre-accident condition? You're relying on the plaintiff's deposition?
Relying on the plaintiff's deposition that it was repaired to his satisfaction, or relying on the fact that he took it back to raise any issues that he may have had. Those issues were addressed. And based upon that, it's our position that it was repaired to pre-accident condition.
Right. Can we shift to loss of use for a minute? And let me just give you a hypothetical. You and Mr. Monaco are involved in a car accident and you strike the back of his car. You're probably a very safe driver, so I know that would never happen, but let's assume that you do. And he's driving a $150 BMW. I'm sorry, $150,000 BMW with all the safety whistles and everything imaginable. And it's totally your fault. His car has to go, his $150,000 BMW has to go into the shop, and he gets, for loss of use for a month, they give him a lower end Nissan Sentra. Do you think that makes him whole for that period of time that he's without loss of use of his $150,000 BMW?
Well, as your Honor pointed out previously, there's nothing in the record to suggest what kind of replacement car he had while his vehicle was being repaired.
Right, but my hypothetical is with respect to a Nissan Sentra as opposed to a $150,000 BMW. Or let's say Mr. Monaco has a minivan and he has 5 kids, he's driving to sports and all types of activities, and you give him a VW Beetle. Say, here you go. And the Beetle works great. Nothing wrong with the Beetle. Is that, does that make him whole? Does he have a loss of use claim there with uncomparable vehicles?
Well, I think each case is going to be fact specific, but based upon your hypothetical, I mean, he gets a replacement vehicle. I'm not sure that it's anywhere where it's written that he has to get a comparable vehicle.
You might be right on that. I know Judge Doran had ruled that way in that Jacobson case is just a trial level, but it may be you're right that any vehicle will do. Here's a 1973 car. It runs. And I know you had a 24 Lexus, but here's this car with no airbags, no stereo, but it runs. So knock yourself out. I mean, that's an absurd one. But if you're saying there's no principle of comparative vehicles, that's where we could go.
And I don't believe there is.
Okay. Yeah. So any vehicle in your view, and that's reasonable, but anything that runs will do. And if we follow your interpretation of the law, if we follow Judge Doran's interpretation, it has to be somewhat comparable. So we'll have to take a look at that. It is an issue of first impression for us here. And it probably comes up in insurance context a lot, I think, perhaps, but this is a little different. Anything further, Mr. Cosgrove?
No, we're relying on our papers, Judge.
Thank you very much.
Thank you.
The court will stand in recess.